order of the Lawrence Court below. And another, my lord, your lordship was pleased to target this case, my lord, to dispose of by the Lawrence Court below. But it was rejected again. For that reason, my lord. Rejected again means, my lord, have targeted the court. Your lordship was pleased to direct this present petitioner to move affairs before the Lawrence Court below for release of the money of the present petitioner, which has already been deposited in the bank account. Okay, take it. Let's see. And another, my lord, challenging the order of the Lawrence Court. That will come in, my lord. Order to mention, item 134. Weekly list. The grants of 2011. 11. What are you already? You not to fix it. Any, I will take only 5 minutes. It is fixed already. Come at 3:30. 3:30 upon data matter. Every day that even if I fix it, the same thing will happen. So even if those two matters are there, it may not be taken up also. You should get ready. Let it be there. Every day at 3 o'clock and all, you should be ready. I can pick up any day.
It's a fresh matter, it's a vigilance matter, criminal appeal, my lord.
Fresh matter?
Yes.
After commission, appeal?
Yes.
Please.
My lord, I've given.
Pardon the mention, my lord. The urgency, quashing of the order of cognizance in this case.
Cognizance quashing is never urgent.
When the urgency is that the interim order passed in this case was for a period of 8 weeks. Now the said interim order has been lapsed, my lord, and it was listed on 2011-2020.
What will happen then? Nothing will happen.
The stay has been granted.
We'll see, but no urgency.
Let me mention. One LMC of the year 2006. This is relating to the Baleswar sex scandal matter. In this case, the Honorable Court has passed no further the order has been passed in this case. But my lord, the learned trial court has issued summon against
2006 property. Take it. How this matter is escaped?
6.
How this is?
They are giving me as well in the work files. Check again and again.
2015 everything came and 2016 is escaping. I've asked that wherever there is interim order operating, we leave those matters. Yeah. And all the matters are listed. How it is escape, I don't know.
hearing item number 1. Mr. Maharaj is present last time we mentioned.
We recall the
One.
escape and who is responsible for escaping. Get a report.
One, Lord, Mr. Maharaj is present. Last time mentioned, we called him Mr. Maharaj. Last person.
See, if I get the time, I'll take it. Even today, I'll take. I'm telling you.
Tomorrow,
You come to the tea. If it is there, I'll take it.
exam method. Just the transmission, I will shoot after by the CBI.
Give the memo sheet. Yes, sir.
Item 64, madam. How to tell is there.
I'm for the
Today,
Madam, my trial is
When 64 will come, you tell me, I'll just adjust it. Okay.
I got it there.
Okay, 64.
Item 69.
before 1890 days, madam.
We'll see. I'm not sure which date, but interim order there. Okay, interim order continue.
Item 69. The joint affidavit was to file, and the other side counsel today called me, and his client is not there. Our marriage went outside.
64.
Item 60.
60.
Finally taken out after 1 week.
Interim order must be there.
Only joint affidavit question for
The problem, say that you have settled already. Thereafter, you keep on asking for time.
no, the other side was absent due to
Reason, I'm not on reason. Reason is once interim order is taken on the ground that settlement is taking place.
Yes, madam.
Already the day when the matter is taken up, you should be there. You are not there.
Already agreement,
Take interim order. Thereafter, keep on asking time.
already agreement was there before the puja committee. Only they have to present today.
I don't know. Then I'll 2016 matter. Interim order is going on.
Next week, every day, she will come and file the appeal, my lord.
It is made clear that if the next date appearing, if the parties will not file necessary affidavit, the interim order passed in this matter, which is operating since 2016, shall be automatically vacated.
My lord, weekly.
I vacated it. 2016 you were taking it.
next week, I'm putting in next week. If you don't do it next week, it will be obligated.
They has to file the affidavit.
I'll vacate what? You are persuaded. Otherwise, I'll vacate it. What to do? 2016, just imagine.
When on married also, it was not there.
Other than,
I will have to argue the matter, but if your lordship,
then get ready for next week.
next week, only mention that
Next week with this order.
I
Parental order has to be there. Otherwise, there is no end to it.
My lord,
Item 56, Item 56.
Yes.
I have instruction to appeal for OP1 and 2 also notice are issued, but I have not get the booklet.
Who's for petitioner?
Mr. Tripathi, Bomanand Tripathi, I will inform you.
No, you have you informed?
No, my lord.
See, then he will come behind my back to adjournment. You come at that time, I will adjourn. You could record adjourn, but let him come.
Yes, sir.
I will adjourn it, don't worry.
Yes.
my lord, weekly list item 32, criminal appeal, my lord, 2007 matter,
2007.
my lord.
Yes.
I'm praying for hearing, my lord.
No?
I'm praying for an hearing.
Which one?
Item 32, weekly list, my lord.
It will be heard, don't worry. It will be heard. Get ready. If they are in the list, then it's supposed to be heard only.
My lord.
Yes.
My lord, item 55, yesterday I had filed a withdrawal memo.
Okay. Withdraw. Yes. Anything? Yes. We should know this today.
Item 1.
One.
Item number 53, Lord. And
No, there is a mentioning. Yes. Item?
Item 53, Lord.
What do you want?
Lord, kindly that some other day. That only the notice issue, no entry mode is there, Lord.
No, this is sufficient. I'll adjourn it, but at its own turn. Let us see who is appealing.
Definitely, please.
Of course, कर दो मते ठीक है जी हाँ
Item 1.
May I please, ma'am?
yes
Sure, my lord. In this case, the order taking cognizance is under challenge, my lord. Even accepted the contents of the FIR and the chargesheet. No offense of 420, 68 and 471 is made out against the petitioner, my lord. The petitioner is a practicing lawyer, my lord, and in discharge of his duty, he has his signature as a witness in a registered cell deed, my lord. So he has no knowledge that
let us come to the charge sheet.
my lord. Lordship, kindly please, what is 29?
Your name is Pradeep Kumar
Garnack.
Garnaik. Yes,
Page 29, my lord.
yes.
That is the brief fact of the case. The investigating authority has,
What is imputed against you?
my lord, only that, my lord, that I have put my signature in the.
Let us see.
Yes.
Let us see. Yes.
Middle part, my lord. Page 29.
It is impersonation.
No. My role is that I have put my signature in the registered cell deed as a witness. Accepting that, my lord, the offense under section 420, 68 and 471, how it will be against
Show me the statement, 161 statements.
my lord.
Yes. Yes, Mr. Jana, have you seen it?
My lord, the lordship's 161 statement is not okay. But your lordship may kindly see, they have fabricated the legal air certificate. Thereafter, they have, as per the,
Those who are the beneficiaries
of this gentleman.
and he has identified this person. In this area.
Identify which person. There is an impersonation.
There, my lord.
And then it is part of impersonation.
Identified the advocacy Pradeep Kumar Garnaik, my lord, in this cell, my lord, unless he has been identified that this is their person, my lord, then he is also like me. I am soliciting the lordship is.
Impersonation.
No, impersonation will not come, my lord, because impersonation offense is not there.
How have you identified them?
My lord, the registered cell deeds, I have only put my signature as a witness. Also, my kind of
The case is registered cell deed is a outcome of an impersonating document.
my lord, a legal certificate.
You are a lawyer, you are identifying.
My lord, legal certificate.
You are instrumental in giving a belief to the person who has purchased that the person who is selling is a correct.
No, the transaction was not there. The selling was not there.
All these things will be decided, sir.
The ceiling was not,
Show me 161 statement. This is nothing.
my lord, the 161 statement of one Gopalandu Sahu.
ସେଇଟା ସିବି ଆଣିବ ନା ଆପଣ ସେଟା
Please take it up. I'll just
Yes.
hear it. Get on.
Lordship may call it,
But why don't you argue all these things there in before the charge court? No.
kindly.
See, then I will have to evaluate everything. You move an application, specific application, and give a direction that it has to be dealt a speaking order has to be by the trial. Everything will be there before trial court, right? It is not a challenge the order. No, one minute.
This order, my lord, only I pray, my lord. Lordship may kindly verify the 161 statement.
I'll just 1 minute. Where is the cognizance order?
Nobody has said.
Yes. Where is
And
the
the evidence order, lordship may kindly see. Okay, the magistrate is done. He has only say, my lord,
1 minute. Petition is agreed by the order
Within the-
1872 passed by the court of JMFC CPD in GR case number 664 of 2022, whereby cognizance of offences punishable under section
468 and 478.
468, so it's taken against the petitioner.
Petitioner and others.
Against the petitioner and others. Petitioner, Mr. Mishra, learned counsel for the petitioner submits that the petitioner is a practicing lawyer. He has only affixed his signature in the as a witness. Therefore, in no stretch of imagination, the complexity of the petitioner in the present case can be imagined. Even if the allegation made in the charge sheet and the documents form part of the charge sheet is taken at its face value, no case as such is made out against the present petitioner.
The petitioner will move the application under 239.
I am not inclined to entertain this petition at the stage of cognizance. However, liberty is granted to the petitioner to move appropriate application before the court. 2000 CRPC seeking discharge. If such application is moved, same shall be considered on its own merit, and it is expected that the trial court shall pass a detailed order dealing with the facts of the proceedings. Yes. With this observation, petitioner is disposed of.
Item 2.
Why? What is this matter is about? Mr. Jana, what is this matter you just see?
This is a case, my lord, where this petitioner was working as a government servant, and he has taken misappropriated the money of rupees 1,79,436.
You don't have a case on merit. You don't have a case on merit. Just pass it over. I'll just pass over. Next.
Prayer in my lord.
Pass over. I'm just passing it over.
2,145.
2 and 45 pass over. When 45 will be taken up, 2 also I'll take it up. Okay.
Item 3.
May it please, your lordship. My lord, in this case, your lordship, the petitioner, your lordship, may kindly say Surawala Sahu, her husband has issued a check. This is a check bounce case, my lord. Her husband has issued a check. Her husband is deceased in the meantime, admitted, your lordship. But since I am one of the co-directors of the company, the learned court below has convicted me. The check amount is rupees 17 lakhs. Your lordship, may kindly see, I have already paid rupees 6 lakhs. My lord, may kindly permit me to place annexure 3, page 26. These are admitted facts, your lordship.
What is the order? 8-2 order?
8-2 is that, your lordship. In appeal, I made a prayer that I may be exempted from that deposit of 20%. My lord. That is
what is the check amount? What is the check amount?
17 lakhs.
17 lakhs.
Out of his 6 lakhs I have paid, and it is admitted. Your lordship, may kindly annexure 3 series, page 26.
What is the compensation amount?
27 lakhs.
27 lakhs? 6 lakhs you have paid?
17 lakhs is the check amount. Out of his 6 lakhs I have paid.
20% of compensation amount.
My lord.
It comes to how much?
That is some amount 4 lakhs, your lordship. I'll pay the rest of the amount. I'll pay, my lord. I'll pay the rest amount, my lord.
So what do you want then? You pay?
I'll pay, my lord. I have obtained instruction that I will pay the rest of, because her husband who has issued the check, he is already deceased.
Okay, then I will record your statement and dispose it up.
No, your lordship, may kindly.
Ready and willing to make
Your
good the
lordship,
website directed by the court below.
your lordship, may kindly issue notice. Let him come. I am not praying even for interim order. Your lordship,
You unnecessary keeping pending.
because your lordship,
And
the
rather you, if you have financial stress, you can move application normal order of path.
my lord, the terms and conditions will be settled and will file it before your lordship. Thereafter, your lordship may dispose it off.
Now I'll direct the appellate court to send it for mediation and do it at the same time. Okay.
My lord, may kindly consider your lordship. Since we have agreed to pay your lordship, my only
That is what
prayer
I'm saying. I'll record the statement and I'll ask the appellate court to send it for mediation and settle the dispute.
may not be, my lord. It may not be materialized in the court below, but it will be done here because I have personally tried them to convince them to pay the amount. I will get it done, my lord. Your lordship may kindly record my submission and only issue notice fixing first week of December. I undertake to file the affidavit.
Mr. Mishra and counsel for the petitioner submits that he has taken the instruction from his client that he would be complying with the order dated 8/2/2024.
Your lordship, not that order, your lordship. I'll settle the amount, your lordship.
I know that first 20% of passed by additional sessions at Bhubaneswar in criminal appeal number 79 of 2029. Therefore, in fact, nothing survives in this petition. However, at the same time, Mr. Mishra submits that endeavor would be made to settle the entire before this court by way of mediation. Therefore, he seeks intelligence of this court for issuance of a notice to the opposite party. Issue notice to opposite party within 1 week. Yes.
Your lordship may kindly fix it to first week of December and any date. I'll file it before that. First week of December.
Yes.
Well, I have challenged the order, the rejection of 311, my lord. I am not permitted to withdraw, file a fresh application for the court below, which will be considered.
Mr. Sahul, it is his petition we want to withdraw. Whatever. Mr. Sahul seeks to withdraw this petition to repeat his prayer before the trial court by moving application under 311 CRPC. Such
better application.
Better application under section 311 CRPC. If such application is good, same shall be considered on its own merit.
Yes.
This court has not experienced
This court is not regarding the the case. I know 35 yes.
Item 5. Not item 5. It's a compromise matter, but unfortunately, due to the training program of the informant, she could not appear before this honorable court, and she has requested let my lord to be posted to second week of December, in which my lord.
Second week of December.
Obviously. My lord, I pray.
No. Many cases this same thing happened. You say matter is settled, stay order is taken, everything. Therefore, I just am putting it second week.
What
part? What is the meaning of part?
Your lordship will dispose of this application. ସେ ତାଙ୍କ ଟ୍ରେନିଂରେ ଅଛନ୍ତି ସେକେଣ୍ଡ ୱିକ୍ ଫାର୍ଷ୍ଟ ୱିକ୍ ଅଫ ଡିସେମ୍ବରରେ ତାଙ୍କର ସରିବ ଟ୍ରେନିଂ। ଦି ଜଣ ଯାକ ଗଭର୍ଣ୍ଣମେଣ୍ଟ ଏମ୍ପ୍ଲୟି, ଜଣେ ହଉଛି ଠିକ ଅଛି ନେକ୍ସଟ ୱିକ୍ ଆଇ ୱିଲ୍ ଡିସେମ୍ବର ସେକେଣ୍ଡ ୱିକ୍ ମାଇ ଲର୍ଡ ସର୍।
Second week, yes, next.
Item 6. This is regarding payment of wages, my lord. My lord, page 20. Page 25.
Yes.
This is the appointment of the Pinky Sethi, 25. He is a social worker. She, my lord, the kindly the appointment letter, my kindly.
Why 482 then?
My lord, little more.
Yes.
My lord, his her salary is subject to paragraph 2, my lord. Paragraph point number 5.
Your salary will be paid.
Subject to from the
Yes.
Women and Child Development Department पैसा देले तुमर दिया जीव, that is the appointment letter. ତାଙ୍କର ସେ ଯାଇକି ଗୋଟେ ଲେବର ଅଫିସରଙ୍କ ପାଖରେ ଦରଖାସ୍ତ କଲେ ମୋର 1,44,000 ବାକି ଅଛି। ଆମର ଗ୍ରାଉଣ୍ଡ ହଉଛି ଯେ ଆଜି ପର୍ଯ୍ୟନ୍ତ ଆମେ ଜିଆଇ ପାଇଲୁ, ଯୋଉଦିନ ଜିଆଇ ପାଇଲୁ ତୋ ପଇସା ନେଇଯିବ। ତୋର ଆପଏଣ୍ଟମେଣ୍ଟ ଲେଟର ବି ସେଇଆ। କିନ୍ତୁ ତାକୁ ଲେବର ଅଫିସର ଧମକ ଦେଲା ପରେ ସେ 77,000 ତାଙ୍କୁ ଦେଇ ଦେଇଛନ୍ତି। 1,45,000 77,000 ନେଇଯାଇଛନ୍ତି, ଆଉ 77,000। ତାପରେ ରିପୋର୍ଟ ଦେଇ ଦେଇଛନ୍ତି ଲେବର ଅଫିସର ଆମ ଏଗେନ୍ଷ୍ଟରେ ଅଣ୍ଡର 15(2) of the Payment of Wages Act, cognizance has been taken. That is the case. I have also made party in her. That is my appeal.
Where is that cognizance order?
Yes, my lord, post 30. Post 30. No verification, nothing else, only simple wording that a report has been issued, so cognizance is taken.
15(2).
Yes, that is the case, my lord.
You pay when you will get the money
Yes,
from.
yes, I will pay. I will pay, my lord, sir. That when I shall get the GI, then I shall be clear of that. That is
No, no. Then you rather you pay it and you will get it back. What is it?
voluntary organization.
Huh?
It is voluntary organization.
Voluntary what? What is let us see who are you?
It is voluntary, my lord. My lord. Post 20.
Page 20.
My lord.
Allow issue notice, let us see.
Yes, sir. That is
Issue notice. Let us see.
subject to clearance, subject to getting.
You take out notice, we'll see. Okay. Yes.
Interim protection.
Now you move application, huh? You move application for adjournment. Yes, yes.
Madam.
Item 7.
Say, how much you upfront you will deposit now?
ମାନେ 77,000 ବାକି ଅଛି।
ହଁ।
ତାଙ୍କର ତ ପଇସା ଯାହା ହବ ଜିଆଇ ଯଦି ଆସିଥିବ ପାଇବେ ସାଥିବ।
You deposit at least 25,000 rupees complete say.
10,000 ରେ।
No, what?
ମାନେ ସେ 77,000 ନେଇଯାଉଛନ୍ତି।
I don't know anything.
ମାନେ ଅବଜରଭେସନ ଅଛି, ସବୁ ରିପୋର୍ଟରେ ଲେଖା ହେଇଛି।
Item 6 na?
By virtue of collector's order, I get paid that.
Where is that? 77 seconds.
Only balance 77 ଅଛି।
Where is show me that?
My lord. Yes, sir. Page 29, my lord.
29? Yes. Yes. What does it say?
The case is for 1,35,000. 1,54,000.
Where is that?
My lord, that is para 1, 2, 3, 4, 5, 6, 7 लाइन है।
Page 29.
Page 29, my lord.
1,54,000।
1,54,000। ବର୍ତ୍ତମାନ ରିପୋର୍ଟ 77,000 ନେଇ ସାରିଲା ପରେ ରିପୋର୍ଟ ଯାଇଛି ମାତ୍ର 77,000।
Where is 77,000?
ଏଇଟା ଅଛି।
କୋଉଠି ଲେଖା ହେଇଛି?
Just a minute. Yes, ma'am. Page 28.
28. Yes.
The last para. Therefore, the applicant estimate the value of relief is 77,000.
Or deposit 20,000, huh? Subject to petitioner depositing 20,000 rupees. Proceeding before so and so state. Yes.
15,000.
Why are you negotiating?
Negotiation.
It's all right. Okay. 20,000. 20,000. Next. 20,000. 20,000. What is 20,000 is not a big money.
I said deposit.
Before the court below.
Yes, ma'am.
Before the court below and proceeding state.
Yes. That will not be disbursed because the party will not pay.
Yes.
My lord, that's
Item 7. The informant.
How within 3 days?
What are the offences?
My lord, here, my lord, offences are under section, my lord, 341, 294, 376, 506, 32B, 32BA of the AC and STR. Both are married to each other, my lord, in the meantime.
They are married.
And they have also, yes, my lord, they are present. And
Where is the affidavit?
Affidavit, I have filed, my lord. Informant already filed affidavit, and today, my lord, both of them filed affidavit.
Deepika, where is Deepika's post? Deepika from this side. You know,
Madam, take it.
Deepika from this side. That is the instance of opposite party number 2, FIR number 2, to be introduced. The petitioner, the allegation of the petitioner is not so and so. The petitioner and opposite party number 2 are present in person, being represented by their respective counsel and identified by them. They have also filed self-registered copies of the Aadhaar card to establish their identity, which are taken on record.
Yes.
Investigation is complete.
Completed, but charge sheet not filed.
When the investigation of the aforementioned FIR was going on, the petitioner has married to the opposite party number 2. This is the certificate. Gopal Mandir. After causing, he will harass again.
No, my lord,
What kind of
government employee again.
what is he working?
My lord, constable in the department.
I will record the affidavit.
Yes,
If anything happens, then he will lose his job.
yes, yes.
Because this Sri Gopalji Mandir marriage, whether socially accepted or not, I don't know. Right now, the petitioner has placed on record a marriage, proof of marriage, by way of a certificate issued by Sri Gopalji temple. He submits that he has married with the opposite party number 2 on 20th August 2024. The petitioner has filed an affidavit dated 3/9/2024 inter alia voting as under. Para 3, 4, 234. 234. The opposite party Nitin Kumar. Opposite party number 2 has also filed an affidavit reiterating the same facts, which affidavit dated 12/11 reiterating the same fact, which reflects in para 1, 2, and 3. Para 1, 2, and 3. On query from the court, the opposite party number 2 submits that stated that she is happily married with the petitioner and he has no grievance against the petitioner. Mr. Janna, appealing for the state, submits that the dispute is essentially arising out of a misunderstanding, and subsequently, since the petitioner has already married with the opposite party number 2, and the petitioner being a government employee, government employee has filed an affidavit before this court through his counsel. There is no legal impediment in quashing the FIR regarding that to
One thing of it, because here this is a notary marriage, they registered their marriage.
Otherwise, also under the law, they have to the petitioner petitioner also undertakes before this court that they would be registering their marriage under the due process. That's the due process of law. Yes, of course. Yes.
Item 8.
May please. That's it. This is a case where two neighbors are quarrel and I lost the petitioner lost the affair, and after that the informant lost an affair to escape from the affair of the petitioner. So affair against the petitioner so fast.
I didn't follow what you said.
Whether the petitioner lost an affair, there is a quarreling the mic.
Petitioner lost the affair against
the informant. When the informant lost an affair against the petitioner.
If you do that, what is wrong in it? You might have done something. You have written a fire is registered against you. She might have done something. Might have.
Petitioner is a student and
that's not the. It can't be quashed like this. What is the? What are the allegations?
Allegation is at case.
Yes, Mr. Jana, just seek it. What is this?
What is the
allegation you tell me?
Allegation is my lord. ତାଙ୍କ ଘର ପାର ଆସୁଥିବା ଆମ ଟିପ୍ସ ଗାଡିକୁ ଲିଙ୍ଗରାଜ ମହାକୁଡ ଗାଡି ବାଲାକୁ ଖରାପ ଭାଷାରେ ଗାଳି ଗୁଲଜ କରନ୍ତେ ଆମ୍ଭେ ଆସି ପହଞ୍ଚେ ଦେଖନ୍ତେ ଆମର ଗାଡି ଡ୍ରାଇଭରକୁ ଗାଳି ଗୁଲଜ କରୁଥିଲେ ଆମ୍ଭେ ଆସି ପଚାରିଲୁ ସେ ଉତ୍କ୍ଷିପ୍ତ ହୋଇ ଆମ୍ଭ ଗାଲକୁ ଶକ୍ତ ଚାପ ଲଗାଇ ଚିଠି ଟାଣି ନେଲା ଆମର ଇଜ୍ଜତ ନେବା ଉଦ୍ଦେଶ୍ୟରେ ଆମ୍ଭକୁ ପକାଇ ଦେଇଥିଲେ ଆମ୍ଭେ ପିନ୍ଧିଥିବା ସୁଏଣ୍ଟସ ତଳେ ପଡି ପାଟି କରି ଗ୍ରାମବାସୀ ଦୌଡ଼ି ଆସି ତା କବଳରୁ ମତେ
road race.
ସିରିୟସଲି
It's road race.
My lord, there is a narrow road and there is no.
How am I conducting a trial here?
and now
Then investigation is still going on.
Yes, ma'am.
Then go and tell the police. Cognizance taken.
No, ma'am.
Cognizance challenge for FIR statement.
That's what I'm saying. That's what the petitioner has filed the present petition seeking quashing of for the FIR number so and so. So investigation in the present case is still going on.
My lord, may I
In
permit to.
a stage, I'm not inclined to quash the FIR. However, liberty is granted to the petitioner to apprise the facts and issues as has been raised in this petition to the IO of the case, who shall deal with the same in accordance with the law. You go and tell this thing. Yes.
Please. No, please, your lordship. The petitioner number one is the wife and the other petitioners are the in-laws of the opposite party number two, who was initiated in complaint case and that was dropped due to lack of evidence, your lordships. And thereafter he was filing protest petition. And on that protest petition, again that cognizance has been taken.
Where is that cognizance order?
Your lordship, that cognizance order is not available, but on the same initial statement under annexure 3 that is
Challenging the cognizance order.
yes, your lordship.
Unless you show me the cognizance order,
I have limited for your lordships. Now this matter is pending since 2014. Your lordship may direct to dispose of this matter because that is
you must tell me how many witnesses are there. What you see, everything targeting without knowing anything is pressurizing the trial court unnecessary. Unless you tell me this number of witnesses are there, something of that sort. You have not filed anything.
in the complaint petition there are
Not the usual clerical job you target everything without realizing. You know the problem in the trial court.
yes, your lordships.
Targeting is the biggest problem in the trial.
And the other problem is that your lordship is present.
Realistic targeting can be permissible. Knowing every aspect of it, you know, how much time it will take, how many witnesses are there, all these things.
Your lordship, I will.
That's the whole difficulty. You better you withdraw it and you write all these things before trial court.
I will submit your lordship how many witnesses are there because in the complaint petition itself is provided how many witnesses, your lordship.
100.
No, he is given how many witnesses are there.
How many? Tell me. What have you asked?
In the protest petition, your lordship, there are 3 witnesses.
It's out of what will it go?
Where is the initial FIR? Initial FIR, closure report, nothing. You don't find nothing basically.
Your lordship, the problem is that the record is not available in the code.
File the petition then.
Flexible because
Whatever, maybe then do you think that the court will start searching document for you?
in the code directs to dispose of, then only they will decide the record, your lordship, because systems are.
Make it realistic also. You must assist the court so that some order can be passed.
Lordship, then 10% time so that I could take properly.
You withdraw it and file appropriate application for trial court for expedite disposal of the
Yes, sir.
case. And then come to the court.
As your lordship.
Yeah.
Yes, your lordship.
Right. Petitioner, although has prayed for quashing of the entire criminal prosecution initiated by the opposite party number two against him and other family members in ICC case number 325 of 2014. However, at the outset, he submits that since the matter has been pending since 2014, a direction for expeditious disposal of the trial would suffice. The petition is not supported with all relevant documents. Therefore, targeting the trial without targeting the trial without knowing exactly the number of witnesses and the other aspect of the matter may not be expedient. Therefore, liberty is granted to the petitioner to move the trial court, reiterating the said prayer, if such be considered on its own merit. With this observation, the petition is disposed of. Yes. You say everything that 2014 onwards I have been facing 10 years.
Yes.
So please expedite. It doesn't happen, then come.
Dispute between wife and husband.
Yes.
May I please, Your Lordship? Annexed to page 24, the order for consider the less. My humble submission that the fact of the case is that the present petitioner is the owner of the offending vehicle, Your Lordship, where the 21C of NDPS Act the FIR has been registered, but the copy of found from the vehicle, Your Lordship, that is 384 grams of the 14 phosphate was found from the that that is the allegation, Your Lordship, and the present petitioner owner of the vehicle. The material seized from the exclusive possession of one Jitendra Nanda is the driver of the vehicle, Your Lordship. And the petitioner has been named in the PR, and a final PR has been submitted. And said Jitendra Nanda, he has been arrested from the spot and he has been released on bail, Your Lordship. Only my prayer, Your Lordship, I am ready to participate in the trial, Your Lordship. It will also allow the surrender and release and bail, Your Lordship.
You surrender.
The below commercial quantity 37 is not a bar. Where this person
Then you have don't file a bail. What is why have you invoked 482?
The trial court will not allow the.
That is not the answer.
So
You are apprehending the trial court may not do it, so therefore you file it.
Your Lordship, the final PR has been submitted.
I'll just simply say that you will resort to the remedy and available under law, and it is open for you to seek parity.
Yeah.
That's all. Not beyond that. 482s are not there for granting bail. You have a good case on merits, you can get the bail. What is the problem?
But that only one line is a part of considering the while the trial court will consider the bail application, keeping in mind to the ratio decided in the consequence.
They just come with mind, don't worry. They don't keep mind.
Observation, Lordship,
Judges generally come with the court to the court with full mind.
But
You are agreeing, you mind somewhere else.
Yes, sir. Only that one observation.
Okay, right on. Petitioner has sailed the order dated 26/7/2023, passed by the Learned Additional Sessions Judge, Talipur in 2ACC case number 1 capital A of 2023, whereby cognizance of offences punishable under section
31C of NDPS Act.
21C of NDPS has been taken against the petitioner. And counsel for the petitioner submits that the principal accused, Nando, what is his Nando? Jitendra Nando, who was apprehended from the spot, and the petitioner has no role to play in the entire sequence of the event. Which the accused Jitendra Nando has already been enlarged on bail.
Yes.
Enlarged on bail. Next follow. The counsel for the counsel submits that he would not press his present petition, rather reserve his right to raise all the points at the appropriate stage before the trial court. However, he may be allowed to surrender or appear before the court and resort to the remedy available to him under law. Regarding head to the aforementioned submission, petitioner is granted liberty to appear before the court on or before 30th of November 2024 and resort to the remedy under law. If he moves any application, liberty is also granted to the petitioner to move appropriate bail application, raising all the points, including the point of parity, Such application is moved and shall be considered on the same day. With this observation, the petition is disposed of. Yes. Yes.
So after I'm sorry, Madam, the petitioner called for because they could not present Madam due to some problem, Madam. I mean, because of case and counter case, both of them settle the matter, Madam.
Investigation is still going on.
Over. 341 506 11 to SC state, Madam.
Which one you are seeking to quash? First one or second one?
First one, Madam.
Are you sure that the investigation is over in both the cases?
PS number 30 for now. PS case of 30 number.
No, what are the offences?
Offense number 341 294 506 11
After charge sheet. You only filed the FIR, 2 FIRs, nothing is filed.
341 294
How did I know, sir? Except the FIR, nothing is filed. If after investigation some serious offense would be there, how will I know? No will not help it. Unless I know that you have filed the FIR, except FIR, nothing is filed. Instead, I will certificate. We don't know. After investigation, some serious offense might be there. So file the charge sheet, then only, can be.
Both particular.
Yes. Then counsel for petitioner seeks 1 week adjournment to file additional document to substantiate the case. He further submits that the parties have settled the dispute. Dispute he is at liberty to produce the petitioner as well as the petitioner as well as the informant in the present case in the court on next date of hearing. Yes. Petitioners, yes.
That's all.
Indeed. Yes, next. Yes, madam.
Worship, in this case, my prayer is annexure 2, that is order dated 10/3/2017, when magistrate has been taken cognizance against the petitioner lordship.
Yes.
That's if in this case, allegation is.
Show the charge sheet first.
But see, I am not filed, but charge sheet is here.
How are you challenging cognizance order without charge sheet? File this. The counsel for the petitioner seeks an adjournment to place on record the copy of the charge sheet. Copy of the charge sheet, release the matter after 2 weeks. Yes.
13. Let's take 1 week. Let's take 1 week.
2 weeks to 3 weeks thereafter only. Nothing. I can't adjust the list like this. You should have filed.
Yes, but she kindly sought adjournment.
Next.
13.
Next time, whenever you are challenging cognizance order, charge sheet you have to file.
Yes, Lordship, but sought date, Lordship, kindly given.
At your cost, the other matters could not be listed today. Because I have a cap. This much matter I am capable of taking. 100 matters I have supposed listed. And this kind of frivolous petitions are filed. I saw 50 matters goes like this.
Yes, Lordship.
Then what will happen? With that gap, I could have listed more matters.
Yes.
Please don't do disservice to the, system. And I have already asked the registry that henceforth the matter will not be registered also. If you file the cognizance order challenging, then charge sheet is 100% you have filed.
Sorry, Lordship.
So therefore, henceforth you be careful.
Yes, Lordship. Lordship, kindly give me.
He's giving a time. He'll adjust the board and give it. Okay. Yes. Every day there are so many memos. What to do? We have to adjust them also. 40 plus memos, just imagine. Yes.
My pleasure, Lordship. Petition, my lord, challenge the cognizance order under annexure 3, my lord.
Yes.
Article 25, my lord. Offense under section 294, 323,
294, 323. Yes.
My lord, prosecution allegation, my lord, some borrowed chura, my lord, from the
present informant for which she demanded to return, for which the present occurrence has been done. My lord, the petition number 2, my lord, the informant party member has not whispered a single word against the petition number 2 to allege crime, my lord. My lord, the petition number 1 is also, my lord, has not participated in the, my lord, under section 354, my lord. They have not whispered a single word relating to outrage of forest, my lord.
See, the allegations are just see, have you read the charge sheet?
Well,
Then specific, what have you, with name, CSA?
my lord, name of the petitioner is also there, my lord. Not
Scolded in English language and everything is there.
my lord, the 161 statement, they have not whispered, my lord.
Then so many things, yes. Show me the 161 statement. Reading of the charge sheet, no case is made out.
My lord. My lord,
No case for this petition is made out. Offense is made out. Offense is 100% made out. Just read the
charge sheet 100% offense is made up. You argue that the 161 statement, my current call for the citizen.
No. You argue that at the stage of charge, the petitioner is agreed by the order dated 18/12/2023, passed by Lieutenant JMFC 2 Cognizance Kotak Court Kotak in GR case number 109 of 2023, whereby the cognizance of offences punishable under section 294, 323, 354 and 34 IPC has been taken against the petitioner. I perused the charge sheet and related document placed before the court. Perusal of the charge sheet indicates that the offences indicate that there are specific allegation made against the petitioner. Therefore, I don't find any reason to disagree with the cognizance order. Hence, hence I am not inclined to entertain this petition. At this stage, our liberty is granted to the petitioner to resort to the remedy available to him under law at appropriate stage. Yes. Next.
My lords, petitioner is the complainant.
Yes.
He challenges the cognizance order for not taking some left out offences.
But at the charge stage only you can tell that.
My lords, I am the complainant.
I know that charge stage you tell that the offences further made out.
Further not, in the complaint petition,
which offense according to you is not cognizance
allegation.
Show me the charge sheet. Show me the charge sheet first.
My lord, your lordship may kindly
show me the charge sheet.
The page 12, it starts. My lord, a complaint case was preferred initially. That was referred to the police, and a police case was registered. Police submitted the final report. As against that final report, the complainant filed a protest petition.
Yes.
Protest petition, my lords, as against the alleged offences under section 468, 193, 420, 403 and 409, only 468 forgery was taken.
Where is that cognizance order?
Cognizance order, my lords, at page 11.
11.
My lords.
Yes. Yes.
My lords, the accused OP number 2. OP number 2 has also challenged for quashing of the cognizance order in another separate CRLMs.
Where is,
That CRLMC number 3166.
list the present matter along with the CRLM.
3116.
Yes, list that. Okay. Yes, next.
15. Please, Your Lordship, this is an application for crossing of the criminal proceeding on the ground of compromise. My friend is referring for the OP number 2 informant arising out of the complaint case, my lord.
Offense?
Offense, my lord, under section 436, 323, 336, 147, 148, 149.
Okay. Where are they?
Lord, any date, my lord, they will personally appear.
Why today they can appear?
But first date without a
First day, is there an illegal bar? First day nobody will come.
But
You bring them at 2 o'clock.
but tomorrow, my lord, next week any date, my lord.
Next week, see, how many times I'll tell you, adjusting the board is so difficult. It's very easy for you to take it tomorrow, day after. But it takes a lot of problem, you know, it makes a lot of problem. So, again bring it 2 o'clock so that I can finish it up.
No, they are from, my lord,
Whatever I don't.
Jajpur.
Why you are
Yes, my lord. Well, also,
least it. I can't help it. That's the problem.
but
Then counsel for the petitioner submits that the present case is arising out of a complaint filed by the opposite party number 2 against them, against the petitioners. They have settled the dispute, issue, so entered its appearance for opposite party number 2 on advance notice, leave the matter. Will they kick 30th? 30th. 30th you bring.
30th
That is Saturday,
my lord.
working day we can. Okay, sir.
16.
Thank you, Your Lordship. My lord, in item 16, the petitioner challenged the cognizance order, which is itself hit by article 3, section 3, and article 20 of the Constitution of India. Why I am saying so, my lord? Already Lord National Session Judge, where is the cognizance order? Cognizance page number 18. And Lord Assistant Session Judge, in judgment dated the initiative 2014, already convention applicated I am the accused, and already accused is already acquitted on the judgment. Thereafter, land decision, thereafter land decision, the cognizance acquittal.
Acquittal must be acquittal recorded in favor of other accused person, not against.
Other accused persons already discharged from the police justice.
You tell me real fact, what is it?
My lord.
Who are 5 of you?
Susanto and
Come to the cognizance order.
it's already expired.
Yes, show me the acquittal order.
Acquittal order annexed to 3, my lord.
It must be something else. Must be
Page number 30. 32.
pertaining to which incident?
Husband, my lord. Husband acquitted and others were discharged from the police statute. No time for sure, no permission of the other persons, except husband.
Then therefore protest petition.
My lord. Thereafter, the husband already acquitted because all are discharged from the
Protest petition, how many might have been taken? Where is it? Article 21 of Constitution comes here.
my lord already
Acquitted means everybody has to be acquitted. What?
That's why
She has filed a protest petition also. Just show me 202 statements and all.
statements.
Whether the case is made out or not. Where is the question of Article 21 and all?
200 initial statement recorded by that.
Show me that.
Page number 14.
14.
Sorry, 19.
19.
1920.
1920. Okay. Come there. Come there. Yes.
And
It's pending in 1995. Dr.
matter is
Married to marriage taken place in 1998. Yes, madam. Did you follow what he is trying to tell, say? The husband faced the trial 498, 323 and all. He got acquitted. And the FIR was investigated, the final form was filed insofar as the other in-law family members are concerned. Protest petition is filed subsequently by the complainant wife. And in the protest petition, cognizance is taken. How far you will, make them suffer, the entire family? Issue notice to the opposite party. Opposite party now written to Mr. Naik accept notice for the state. Let counsel for the petitioner submits that for the self allegation, the husband of the opposite party number 2 had faced the trial by a judgment dated 30th August 2014. The additional session judge SPC Jajpur in city session case number 166/2009 have already recorded an acquittal in his favor. Even after investigation, the final form was filed by the police insofar as the present accused persons are concerned. Thereafter, the opposite party number 2 had filed a protest petition and led preliminary pre-summoning evidences. On the basis of the pre-summoning evidences and inquiry under section 200/202 of CRPC, the cognizance has been taken by the impugn order. Thereafter, I done issue notice to the opposite party number so and so, proceeding before so and so state. Yes.
17.
May I please? This matrimonial dispute between the before court so and so. Yes. It's a matrimonial dispute in between the parties. Yes. They married long back in 2004. And thereafter, they have got presently, what are you challenge now? Cognizance, challenge or not challenge the entire proceeding. And in the meantime, cognizance, yes, cognizance, vis-a-vis the cognizance also. Now, I filed the FIR, I filed the charge. And notice, and first step on the matrimonial of the stay proceeding. Why don't you settle? Sir, they are staying in same building. In the ground floor, the wife, the children, and children are also coming to the upper floor. And they are getting coaching from the father. Entire maintenance is being borne by the father. Because of some misunderstanding, the wife is not a mood to compromise. That's the whole matter. And the Chargesheet file, is there any chance of settlement? I don't know. Probably once she comes here, probably that there may be a possibility, because then I send it to mediation straight away. Here, divorce has been allowed in the meantime. So therefore, what I'll do is I'll issue notice, stay the proceeding, and send it to mediation. Okay. They are from Khurda, Bhubaneswar, near Bhubaneswar, right off. The petitioner has assailed the order dated 13/11/2017 passed by learned ACG in Bhubaneswar, whereby cognizance of offence under section so and so has been taken against the petitioner. Petitioner indeed is agreed by the entire criminal prosecution initiated by the opposite party number 2. Then counsel for the petitioner further submits that the petitioner and the opposite party number 2 are staying in the same building. There is a cordial relationship between the petitioner and the children and their children. Cordial. Both the parents have cordial relationship with the children. But both the parents have cordial relationship with the children. However, the misunderstanding between the wife and husband is still continuing. Therefore, the opposite party number 2 is prosecuting the petitioner in the instant case. Regarding head to the nature of dispute and the relationship between the parties, it is apparent that the parties may settle their dispute if it is sent to mediation center. Therefore, I am of the considered view that the parties may be relegated to the High Court Mediation Center, coordinator to be issue notice so and so, and further proceeding in so and so state. Yes. awaiting mediation report, finish the matter. You mediate, may, out of pressure, she may, the wife is not in a mental condition because he has got the divorce. He filed another petition against the protection of women that was dismissed. Divorce was allowed. And he's happy with the children, and father is also happy with the children. And father has kept 12 lakh odd rupees in the name of the wife. She's getting 12,000 interest per month. Everything is all right, but probably mentally, what my instruction, she's mentally not fit. That's what the reason. Let us see if something can work out. Let us see. Yes.
18. May I please? For the present petitioners are three brothers who are challenging the order of cognizance under Annexure 3. You actually see the order itself. The order itself is informative, Lord. Annexure 3 has page number 1.
Marriage petitioner nobody party number 2 has already been dissolved by order of the competent court of competent. Yes. Yes.
Yes. My lord, the petitioner challenging the order of cognizance at page number 29.
29.
Yes, Lord. Annexure 3.
Yes.
So actually, I'll place the order dated 1/9/2020.
Yes.
My lord, charge sheet under section 341, 294, 323, 506
Yes.
has been filed.
Yes, I think it. No.
Lord, and
Yes.
charge and the cognizance has been taken adding 354, my lord, without giving any explanation.
Let us see, come to charge sheet.
My lord, charge sheet on the same para.
You are agreed by 354 only.
354. And so far as this case is entirely about the, my lord, the civil dispute has been giving a color of criminal offences and registered. The FIR has been admittedly filed after 2 months of the alleged occurrence.
Charge sheet was not filed.
No, my lord.
354.
Charge sheet, I have also annexed the certified copy of the charge sheet under Annexure 2, your lordship.
Come to the statement of the victim.
My lord.
Under 161.
Yes, your lordship.
Where is that? What is your name?
My lord, all the three petitioners, in fact, six petitioners have been named in the FIR. Charge sheet has been filed against 3 persons only, represent 3 persons. Bhaskara, Panchanana, and Sudarsana. Informant is your lordship, namely Satyapriya Jena. I am placing his lord statement. And moreover, the my lord, charge sheet itself indicates that both the informant and the petitioners are brothers. They are fighting for their civil dispute for ancestral property, and cases and counter cases filed against each other. But so far as the 354, there is no material after charge sheet, my lord. The magistrate, though taken cognizance without explaining how, my lord, from the material, which material 354 will be attracted, there is silent about the cognizance order. Let me place the statement, my lord, of Satyapriya. One more call that time.
Yes. Really?
My lord. Yes, your lordship. Let me place it.
Yes, yes.
मोर नाम सत्यप्रिय जेना बयस 53 वर्ष पिता भीमसेन जेना जे कातुआ ग्राम स्वयंस आज 31/3/20 लिखर आपनको पूर्तवर मौखिक जमान जे गत 9/12/2020 लिख समय प्राय 7 घंटा अपराह्न 2 घंटा हम मु आम घर बाहर दांड को जाऊली आम ग्राम दांडर जीवा समय पूर्व शत्रुता को केंद्र करी आम ग्रामर 55 जेना सुदर्शन जेना भास्कर जेना ओरफ जितु हाथ में ठेंगा काटी धरी मत रास्त अटकई ग्राम दांडर मत अश्लील भाषा यथा स्वयंस आज मारी शेष करदेबू बोली कही धमक देले मत माड़ मारे मु बहुत दिन हम बोली पचार आम ग्रामर केतक लोक आसी पहुंची मत से कबल उद्धार कले से माड़े ମୋର ପିଠି ମୁହଁରେ ଆଘାତ ଲାଗି ଖଣ୍ଡିଆ ଖାବରା ହେଇଛି। ଏଇ ସମୟରେ ମୋର ସ୍ତ୍ରୀ ଆସି ପହଞ୍ଚି ମତେ କେରାଣ୍ଡିଆ ଗ୍ରାମ ପଞ୍ଚାୟତ ଚିକିତ୍ସାଳୟକୁ ନେଲେ, ଚିକିତ୍ସା କରାଇ ଘରକୁ ଫେରିଲେ। This is the statement. Nowhere 354, so far as the Lord offense against the woman has been also been implicated in the statement, as well as in the charge sheet itself clearly indicates your lordship and your lordship to the charge sheet part at annex at page number, your lordship need come to page number 27. The observation note, brief facts of the case.
ये सत्यप्रिया is a lady or Satyapriya or Satyapriya? No, it is written Satyapriya.
But
maybe my state is confused.
But this is the statement. But your charge sheet has been submitted under some of the offences.
There is no number in thing.
Yes.
There is a confusion regarding Satyapriya or Satyapriya.
So 354
charge sheet is written Satyapriya.
Satyapriya. I'll take your lordships to be again to be cognizance of that. To be page number 29, Lord. On the 9/2/2018, it was been stated. 354B and 379 was added at the time of registration of the FIR. Lordship got it.
Yes.
But due to addition of 354, now I have to go for the trial before the higher forum. And there is no material at all.
The Supreme Court proceeding. Proceeding engaged charge sheet. The Supreme Court is released.
Charge sheet is vividly described the entire incident, how these 6 persons have been added and how they have been mirrored.
Madam, petitioner has challenged the order dated 1/9/2020 passed by the SDGM Puri in GR case number 272 of 2018. Whereby cognizance of offences punishable under section 342/342/394/323/506/354/34 IPC has been taken against the petitioner. And counsel for the petitioner has taken me to the charge sheet and the statement of the victim recorded under section 161 CRPC. Perusal of the charge sheet and charge sheet indicates that reveals that the charge sheet was although filed for alleged offence under section 294/323/341/506/34 IPC, but the court below has taken cognizance of offences under 354 IPC beside the other offences as has been filed in the charge sheet. The petitioner has a limited grievance regarding the filing of regarding the taking of cognizance of offence under section 354 IPC. 354 IPC. Issue notice to opposite party number 2. Opposite party is not a.
Yes, well, I have to ask.
You have not.
Government is the party. I'll add, my lord.
Why are you doing all this thing? I don't understand.
State was a party. So
that's right, but see, these are the internal dispute between the family. These are minimum things.
Immediately, my lord.
How will you do it now?
My lord, your lordship will permit just now.
Where?
Here itself.
You come inside the computer and do it. You have decided not to get any relief from the court.
Course of the day,
do it and then I'll pass the order. So keep it.
In course
of 2 weeks.
In course of the day.
Why are you doing all this? This service to your clients.
I'm sorry.
Issue notice to the state, Mrs. Naik, accept notice, and then counsel for the petitioner submits that he would implead the informant in the present case as opposite party number 2. If opposite party number 2 is implicated, during the course of the by tomorrow, notice be issued to the newly implicated opposite party number 2. Please the matter after 2 weeks. Yes.
19 stay of for
No. Because you have not filed a proper petition. That's all. You move an application. There.
Once your lordship.
You move an application. I will not.
I'm sorry.
No, nothing. Nothing. You should learn lesson at your stage at least. Having this much exposure in the law, how to prepare a petition.
I'm sorry, your lordship.
That's sorry has to bear some cost.
My lord, once they
move an application, additional application for stay. Then I'll do.
I will proceed your
related procedure only calling there is nothing. I can dispose it up saying that you raise all these points at the stage of framing of charges. Why I am doing it, you know? Because the magistrate might have committed a mistake reading the name Priya. Therefore, I am issuing notice. Otherwise, if 354 is made out or not, that is at the charge stage it can be decided. I can state it very I can say that. I'm disposing that the petition.
Magistrate tribal charge.
I'm trying to help it out because see, the allegations are
only.
So I wanted to set it, but subject to issue. And you have not included the other parties.
In course of the day, it's
do it. See. Next. Next.
May I please the lordship?
20, yes.
And the time challenging, the petition is challenging the order of convenience.
Yes.
Taken under section 138 of the NI Act.
Yes, sir.
My lord, why the annexure 4?
You are the accused.
My lord.
What is wrong in it?
My lord, the check is sued in the for a liability.
19?
It's 19.
Okay.
Yes, my lord.
Yes,
19. My lord, the check is sued in a discharge liability under a void agreement cannot be enforced under law. In the present case, when the vehicle is in hypothecation, without the permission of the bank, the agreement was executed and a post-dated check was issued. So, on that score, the agreement is itself a void.
And those things can be tested in trial only. I can't go into exactly convenience. Let me check. And it was dishonored. The notice was given to you, you have not answered that. And complaint is filed. That is enough. For taking convenience, what to do?
First of all, the check is post-dated, and on the date of issuance, on the date of issuance, there was no liability.
I don't know. All these things can be only looked into at the appropriate stage. My lord, the convenience says, how can I go in?
My lord, can you see the agreement itself is a void one?
My lord, the Delhi High Court in Virendra Singh versus Lucknow hearing.
That's my lord, in the consideration of or object of an agreement is unlawful, illegal or against the public policy, the agreement is void and legally unenforceable. As a result of this, any check issued in this
which paragraph you are reading?
My lord.
Para?
No, my lord.
Which is the relevant paragraph?
No, that can we see last rules. My lord, in the present case, neither party is a victim of exploitation.
This will not be applicable to you. The last paragraph. It is after the conviction.
My lord.
It was not at the convenience stage.
My lord,
convicted by the first court, then he went to the regional court, appellate court, thereafter regional court. In the regional court also convicted. Then he went to Supreme Court by NSLP.
My lord.
Then that order is passed.
My lord,
thereafter, you are coming at a convenience stage and you want me to look into the validity of an agreement. How can I go on to
in the agreement, it was written that the vehicle is in hypothecation.
I can't go into that.
When the vehicle is in hypothecation, whether it can be entered into.
Maybe you are correct, but not at this stage.
The agreement is on a void one.
That's right.
So that's good cognizance, my lord.
Can I, in this proceeding, can I declare that agreement to be void?
My lord,
Unless that agreement is judicially decided to be void.
my lord. My lord, both parties in the agreement are declaring that the vehicle is in a happy position.
That's right, but see, I don't know, how can rather I am trying to convince you, and you don't have it.
My lord, let it, come on, I also, other judgments, so I have not,
You raised all this point before the.
No, my lord, my lord, cannot put adjourn to any other date.
No, what is this?
I will always order similar cases for convenience.
Sir, you have shown the judgment, you have not read the judgment, read the judgment. You read the last paragraph of the judgment.
My lord.
Last paragraph of the judgment. Read it loudly.
In the present case, neither party is a victim of exploitation.
Paragraph of the judgment.
Manner, with the observation this revision petition is allowed. The petitioner is acquitted. However, the petitioner has already paid a sum of rupees 1
But
lakh.
after conviction, all these things have happened. He has faced the full trial. And then after the full trial, the court examined that, then the court says that yes, the agreement was void, and the check was a culmination of issuance of the this thing from that void agreement. So therefore, acquittal.
Mohammed, kindly, it may take up next week any day, I will convince man.
It is only burdening the court, nothing will happen.
No, why not I will follow status.
Release it after December.
Oh.
You don't have a case. Yes.
20 marks, sorry, 20. In this case, though, the order of cognizance.
Yes.
Take a before that, the annex of 4.
You are refused.
Minute. Annex of 4, there is a missing of FIR in 2020. And thereafter, a issue of a complaint case by the this complainant, Annex of 5. Thereafter, issue a illegal notice, and thereafter, a file this present case, Annex of 1. When check was issued and he written in his FIR that
where is the proof? And he will prosecute you for 420 separately and 138 also.
These check were issued missing in 2020, and
this thing has to be tested there in trial. I can't. These are your defense
before the in the charge, but the learning court below stated that it will not decide. It will decided at the time of
obviously.
Because when check was missing and all the was stationary entry was there.
At this stage, the cognizance stage only, you want everything to be decided. How can it be possible?
Only direction to decided at the time of framing of charge.
No. I can't. You raise on the appropriate stage, antenna. The petitioner is agreed by the order dated 1/8/2024, passed by the learned SDGM and Jagatsinghpur in ICC case number 65 of 2024, whereby cognizance of offence punishable under section 138 NI Act has been taken against him. Besides many other ground, the petitioner has taken a ground that for the same on the same allegation, the opposite party has also initiated, also filed an FIR, being FIR number Jagatsinghpur vs case number 784 of 2024. At the next I'm afraid at the stage of taking of cognizance of offences, this court can go into all these issues. Therefore, I'm not inclined to entertain this petition. However, liberty is to raise all the points before the court below at the appropriate stage. With this observation, the petition is over. I'm just
petition of CRPC to release his vehicle matter
which has been implicated in a case under section 52 of Odisha Excise Act, my lord.
Yes.
That has been rejected, my lord. Petitioner is not back.
457 application.
My lord.
Against this revision lies. We'll file revision before sessions court.
My resolution says lots of remanded the matter for fresh consideration by taking note of this.
But that's right, but you have filed a revision petition, sir.
कोई कल में रिमांड करते हैं.
I might have said that, you know. Yes. It's all right, you go and tell the revisional court.
रिमांड है आउथर विचार में जजमेंट विचार ये है कंसीडर.
I can't exercise that jurisdiction at all because the revision lies against this. If I entertain and everybody start moving application under 482, the revision lies against it. Seeks to withdraw this petition to file revision against the criminal revision against the in order dated 3/9/2004. This liberty petition will dispose of. Yes.
22 minutes में कहीं डायरेक्टर ने तो रिटर्न जाके बस सर्टिफिकेट दे देना.
हाँ, certificate copy of letter replacing the photocopy. Yes.
I will appear for the informant.
Yes.
On that matter, where your lordship was pleased to grant me an opportunity. I am having the downloaded copy. If your lordship will see, I am marked it.
Yes.
In annexed as annexure 3, your lordship can see that copy and annexure 3 to the petition.
511 and 511, two orders.
Yes.
Depend करे अपने जैसे कहिए सकते.
Yes. Further argument is taken place, huh?
Yes. 511, your lordship.
511 that is annexed as annexure 1.
Public prosecutor and defense counsel are present. Argument for the side of defense is resumed. Argument is closed, but judgment is there. Yes.
Another argument has come. Only intention is to protract the trial.
Millets, I am here, Millets, if the lordship will kindly have a glance to order 511/20.
I is arguing, although the petitioner hasn't started, I may be permitted to submit.
No, one of you can be permitted to.
Yes.
You decide who will argue.
Lords, it's my case. So the petitioner's counsel should submit. But who is submitting? It is the opposite party's counsel.
No, that I'll take care. But now I hear the counsel appearing in person or here or you.
There were two petitioners. The same two petitioners are petitioners here. But your lordship is being made to understand that another petitioner has now filed today. It is not that. Now your lordship look
So
at
there are how many petitioners here? Here two petitioners.
They both
Same
same.
two.
Hella, seta ଗୋଟେ mistake ହେଲା seta ଗୋଟେ
Now your lordship look at annexure 1.
Let us understand what is exactly. Yes. What
Your lordship may kindly see annexure 1.
you are agreed by what order?
Page 10 minutes.
Page 10, you are agreed by this order. Huh? Page 10. Yes. It will mainly so the apparent call Hazira, equal person so.
The second paragraph, my lord, please.
You are agreed by this page 10.
No, I am agreed by the second paragraph, my lords, and the third paragraph. The second
Which
paragraph
page
is
10?
like this.
Yes. Let public prosecutor and defense counsel are present.
Yes.
Argument side of defense is
Side of
resumed.
defense resumed. Arguments from the side of defense is closed. That is the part which I dispute. I did not close my arguments.
Defense counsel are present.
I did not close, I am telling your lords. Why I did not close, I am telling your lordship. By 5/11, certified copy was not with us. The copy containing your lordship's observations. That I have annexed now as annexure 3.
See, Mr. Panda, I'll tell you one thing. I can't sitting here in the High Court control how the trial court will proceed in the argument. You have argued partly.
I am
It is
not
now
saying
concluded. What can I do?
Your lordship may just bear with me for a moment.
Yes.
This is a case which was instituted at Ballyguda, my lords. Sessions case started, my lords. 2 witnesses were examined. I'm only recapitulating the history. 2 witnesses were examined. Unfortunately, they did not support the prosecution story. That led the informant, that led the victim. She is not the informant also.
It's all right. I understood it. But the trial court has given you opportunity to file written argument and citation will do it.
Use of this opportunity. What is the use of this opportunity? Your lordship knows, and I probably think that Audi altera pattern is something which is basic, my lords. That an opportunity of hearing is to be given. Now here,
what is the question of audio alternate pattern here? You have been heard at length.
They have not been heard. No,
it doesn't reflect on the interim order. How much time you have heard? An argument. See, I'll read once again. I'll read. Learned public prosecutor and learned defense counsel are present. Argument from the side of defense resume. Resume means what?
I don't dispute.
I read the simple English here. And thereafter it says that argument from the defense is closed. You are agreed by that sentence. You are agreed by the sentence. And read the next paragraph. At this stage, learned defense counsel prays to file citation and read the argument.
Your lordship may just.
What else you need for that? I don't think that interference is called for in this situation. It's an extreme case.
I am not asking your lordship to interfere. Pass whatever order. I have got nothing to do with that. The lordship may just hear me for 5 minutes. The history of this case.
No, I'm not arguing. I'm not hearing.
5 minutes ଟିକେ ମତେ ଶୁଣନ୍ତୁ.
ଆପଣଙ୍କର ପ୍ରେୟର ଦେଖନ୍ତୁ ପ୍ରେୟରରେ କଣ ଲେଖିଛନ୍ତି ଆପଣ ପ୍ରେୟରରେ ଲେଖିଛନ୍ତି ଫର୍ଦର ଆର୍ଗୁମେଣ୍ଟ କି ଅପରଚ୍ୟୁନିଟି ଫର ଫର୍ଦର ଆର୍ଗୁମେଣ୍ଟ is called for in this kind of situation.
ମୁଁ ତ ସେଥିଲାଗି କହୁଛି after 5 minutes your lordship can pass that order.
Yes, you could argue, no problem.
I am only submitting. This is a case which was instituted at Ballyguda. Petitioners are not named in the FIR. They were arrested, taken into custody. Trial commenced. 2 witnesses were examined at Fulbani, at Ballyguda. They did not support the prosecution story. Prosecution came up in a transfer petition. The transfer petition was allowed. Trial was sent to the court of the sessions judge at Berhampur. Trial commenced, my lords. Trial commenced and prosecution evidence was concluded in the month of July 2024. Thereafter, my lords, accused statement was made. Prosecution arguments were heard. Then my arguments commenced. I have taken adjournments, I concede. I have taken adjournments. The court has been liberal and granted me adjournments. Now, what happened is, I moved a petition under section 41. That was rejected. Then I moved a petition. These are all in course of arguments. Then I moved a petition under 311. That was rejected. Against that, I came up before your lordship. Your lordship did not allow that, but your lordship gave certain observations. That order, my lords, was not with me on the 5th. When I commenced arguments, I sought for an adjournment after some time, saying that I will produce materials as well as the order. Now the court writes that arguments are concluded. The court has granted me time to file written notes and citations, my lords. I am not on that. I am only asking, my lords, one thing. can an accused, my lords, who is facing trial for capital offences, my lords, can he be treated with in this way? Now, so far as the other earlier order is concerned, in the 41, in the 311 petition, that order sheet is there also with your lordship. On the date that order was passed, I was at Parampur, my lords. I have seen, my lords, counsel asking for time, but the order sheet reads elsewhere, reads otherwise. Counsel told me that he will move for transfer. I told him, my lords, that it is not desirable that you move for transfer, because you should not see, you should ensure that the court, you should not lose a court. That was my advice. Now your lordship may decide whether this court is doing the right thing by deferring, granting a short deferment for me to place arguments. Then why should there be the necessity of arguments, my lords? As it is, my lords, the accused who faces a trial, until he gets police papers, he doesn't know what are the materials against him. In no sessions trial, my lords, public prosecutor opens the case and says what is the nature of evidence he will bring. Case is closed, my lords. Just because a target is set, does it mean that the accused is precluded from continuing with arguments?
Well, you are not precluded. If you need to be arised, then you will be heard. I'll record that. Right.
Posted it tomorrow for judgment.
I'll record that.
Posted to tomorrow for judgment.
I'll record that. Right. All right. The petitioner, the present petitioner is.
Your lordship may not interfere, I say so. But your lordship may take note of the fact that accused are handicapped. That is all I request.
Yes. Petitioner in the present petition is exploring the following relief. It is like the petitioner be permitted to further argue the matter sheet. Okay. The matter is at the trial is at the final stage. The matter was heard by the court below, and on 5/11/2024, the following order was passed. Learned counsel for the Mr. Pandal and counsel for the petitioner is agreed by the aforementioned order because his argument has been closed while closed in between and he submits that he had never concluded his argument. The trial court appears to have resumed the argument of the defense counsel on 5/11/2024 and subsequently closed the oral argument. However, liberty is granted to the petitioner to file written argument and also to file this relied upon judgments. I see no reason to interfere in this matter. Hence, the present petition is dismissed. However, dismissal of this petition shall not preclude the petitioner to be heard if the trial court feels it necessary for any clarificatory argument at the while before pronouncement of the judgment. With this observation, the petition is disposed of. Yes. Next.
And can a copy of this order be uploaded on the net today so that it
Yes. I'll do it. Yes. Yes. 22.
Item number 23, my lord, was pleased to fix it at 3 p.m.
Yes.
Instead of 3 p.m., my lord, maybe it's next week, any date.
Who is appearing for the?
I am appearing for the petitioner and Mr. Mahapatra, senior counsel. He is appearing for one petitioner.
No, he will come and say that 3 o'clock will say.
Yes.
No, I can accommodate you next week or next week.
Oh, it was specifically adjourned to 3 p.m.
That's right.
I will inform Mr. Mahapatra.
You inform it, note it down. We will put it, let it be on 7th.
Oh, any day.
7th is a Saturday, is working day.
7th December.
So that we can at least coolly hear it.
Okay.
Without interruption.
I'll be in between of marriage, madam. Because Mr. Max on marriage is 6, reception is 8.
Oh, then okay. You may not be there.
I'll be on 5th or 5th, madam.
No, let it be on 30th then. Another Saturday.
No, 30th.
30th. Okay. Yes.
Interim order to continue.
Interim order to continue. Yes.
Similar prayer ballot is item number 61. My learned friend was instructed. If he is ready, but then I will be waiting.
Are you ready?
Yes.
He is always ready. That's the.
Directed to file the legal report submitted by the present accused petitioner. I have already received the legal opinion submitted by the accused petitioner. I have already.
That is there.
Yes.
Give a copy to him. Let him see that. Do you have any
Two questions, my lord, were asked there. What was the letter issued by the manager to the petitioner, and what was his reply?
Whatever instruction he has taken, take a copy so that we can deliver it on here.
High Court was directed the whatever opinion submitted by the accused petitioner to produce his report. That report with me also.
But what are the documents given by the bank to the petitioner?
Whatever, what I am trying to say is, whatever instruction you have, if you don't have any problem in giving it, it's not privileged document. This is all from record. You give a copy to him so that he can address. Give a copy and list it after 1 week. Give a copy. Do you have any problem? You have any reservation, must tell. Obviously, these are the document part of the record only you have to supply. There is no privilege communication. You give it.
And what particularly, my lord, the letter which was issued by the manager to the petitioner to give the report, that has been seized by the investigating officer.
Let us see what is giving. Otherwise, we will deliver it after 2 weeks.
Interim order to continue.
61 item. Yes.
24.
Your Lordship, in the present application, the petitioner challenges the propriety of the order passed by the Honorable Special Judge Bhubaneswar, wherein the court was pleased to reject the discharge application filed by the present petitioner. Now, not going to the factual matrix because this is involving a clear case of discharge, we are just relying on 3 points of law on which we are basing our prayer. The 3 points are that one is that there must be an existence of a scheduled offence for a PMLA proceeding to be launched. Now, this PMLA proceeding arises out of 2 cases, that is Marital case number 646 of 2022 and
the predicating offence may exist or not. Mr. Agarwal's presence is enough for you. Yes, yes.
My lord. So 2 cases are,
there is no predicating offence at all. That's what you say.
No. Against the present petitioner, there is no scheduled offence existing.
Okay.
In fact, the chargesheet has been submitted and against she has been exonerated from all the offences. So that is our main ground. Without the existence of a scheduled offence against the petitioner,
you are exonerated. You are exonerated.
No, in the chargesheet, she is exonerated.
Who? The main accused.
The accused, that the petitioner, the present petitioner, is exonerated.
Insofar as predicating
offence is concerned. So thereby, the PMLA proceeding against the present petitioner does not stand at all. Because there must be a proceed of crime in a scheduled offence as per the definition of section 2 proceed of crime and section 3, which is talking about that if there is a proceed of crime in a scheduled offence, then PMLA proceeding section.
I will give you an example. Suppose husband and wife both are prosecuted, okay, for a scheduled offence. And wife challenges that under the aid of 109, wife was prosecuted. And High Court passes it, saying that no case is made out against wife. And the property acquired by wife, which is supposed to be the same procedure to prosecution, that can't be attached.
My lord,
can't proceed against wife.
My lord, I may be.
I'm just giving an example.
My lord, I may be permitted to say that if then that is allowed, then my lord, I have also received fees from my client. In that way, I will be also be added as a.
That's a very extreme example.
And my lord,
I am talking only two accused in a predicating offence. One of the accused is discharged or for any reason.
Right, my lord.
That doesn't exclude the PMLA.
My lord, the Central Biology case is very clear in that.
Show me that.
The para 21, please. Yes.
Para 21 of Central Biology versus State of, Deputy Director, Directorate of Enforcement, which is 2024 0 Supreme Court 833. Para 21 says, hence the existence of a scheduled offense is a sine qua non for alleging the existence of proceeds of crime.
Existence of the scheduled offense is existing. What the other accused?
On my lord,
The entire schedule offense is not being washed away. If entire schedule offense goes, then you are out.
my lord,
That's the distinction.
my lord, the second part of it says that the property derived or obtained directly or indirectly by person.
Sir, that will be tested in the right stage only. I can't at this stage go into all this thing.
My lord, at the stage of discharge only it should be seen that whether there is existing
Again, it has to be tried, whether it is a crime proceed or not, what is the source, and all these things will be tested in the trial only.
My lord,
So something will not help you.
okay, my lord, but we have all other two grounds that we are relying on.
Yes.
The second one is that 44(1)(c) of PMLA, that also demands that if the PMLA proceeding code is different than the court which is trying the original offense, then the records from that court should be brought so that the court which is trying the PMLA proceeding may at least have a look, and in order to verify that yes, what is the allegation that are leveled against the accused, then only from that stage that may be proceeded.
It's not good challenges, then before charge is framed, the entire record from scheduled offense has to be looked into, then charge is framed.
May not be the 44(1)(c) I may be permitted to read. 44(1)(c) says the court which has taken cognizance of the scheduled offense, if it is other than the special court which has taken cognizance of the complaint of the offense of money laundering under subclass B, it shall on an application by the authority authorized to file a complaint under this act, commit the case relating to scheduled offense to the special court, and the special court shall on receipt of such case proceed to deal with it from the stage of it.
On the application, if the documents are not sufficient, the prosecution may move an application. Saying that sufficient documents are there, but is not there, in scheduled offense we have seized those documents, please call and do it. And if they are very confident that all the documents are there, that's the idea of the That's the idea of the
My lord, at the time of filing of the complaint, her name was there, and that's why cognizance was taken.
No, I understand.
But here, if her name is not there, how will the court be apprised of the fact that on the basis of the
something you relied upon that I answered up.
My lord, the third ground I am relying on,
you have carved out the right questions,
right,
but there is answer to that also. That's the problem.
Right, my lord.
Yes, third question.
Yes. Now, the third point is that we had filed a section 207 application before the Honorable Court, wherein we had asked 207 application for supply of the relied upon and unrelied upon documents, and the court had granted that application and had allowed that and had directed the ED to comply with the order of the Supreme Court, Honorable Supreme Court, wherein the Honorable Supreme Court had issued to issue certain guidelines regarding inadequacies and deficiency in criminal trial versus state of Andhra Pradesh, that all unrelied upon documents and a list thereof should be furnished.
Where is that order? Trial court allowing that?
Yes, the trial court order is 151, page 151, annexure
151, annexure 2. Okay, come there. 151. Okay. So this is the impeachment order.
Yes, this is the impeachment order. It ends at 160.
No, where is that order whereby
160
application is and the petition is liable to be rejected? No, sorry, rejected. Considering the both the parties, the prosecution is directed to submit report as to whether any paper document are corrected during the investigation or not. So it is order
151, page 151. Para 2, considering the submissions of both the parties, the prosecution is directed to submit a report as to whether any papers, documents are collected during the investigation but not relied upon on or before 9/2024.
How will you come to
Yes, I have seen
151.
See, the also trying to see the prayer. Here challenging here order 69. He is showing my lord the order dated 7/8.
No, he has a point. Just come to.
He has a point, because I don't know whether this report has, this one.
No, come, just,
This was to submit.
he moved an application, that's running my mind. He moves an application under 107.
Yes,
Okay.
207.
207. And the court says that, okay, you submit the report, date is fixed 9/9/2024. Before the documents are supplied, you proceed in the 16/8/2024 in this application.
No. That report must have been submitted, because after 9/9 he has not submitted that.
In fact, the lordship, at least you should have waited till 9/9 and give all the documents.
Time on the ground, he argued that.
That's the
16/6 also kind of 16/6 order. 16/6.
I'm there, I'm 16/8.
16/6 order, they are to. Whatever document we reliably supplied it. It's not that
Only once the court says that the documents are required to be supplied to him, will the court not wait till the documents are supplied and
where does it say that we have not supplied the document? Now he's arguing something else.
where is 9/9 order just soon?
Well, on the date of filing that was not there.
You show me 9/9 order.
Well,
If in the 9/9 order, if the ED says that these are the documents not supplied to you, then you have a case.
Whatever document will be relied upon the supplier prior to hearing of these applications. It's not.
Where from I'll get it? The proceeding is otherwise.
So it's not the case that he has not supplied the document. Now he's coming up with.
my lord, we are confined to only. My lord, we are only concerned with.
You show me 9/9 order.
We will show if that is allowed for a date. We will show.
If any document which was not supplied is subsequently supplied, then I think you need to.
So in the entire case, it's not allegation that he was not supplied with the document.
It has been shown.
So which part?
In the petition, we have mentioned in the page number. Let's say that last of page number 3. No, page number 4. Page number 4C. It is worthwhile to mention here that after completion of her appearance before learned court below, the petitioner filed an application therein, section 207 of CRPC, in view of the judgment of the Honorable Supreme Court in India in the matter of imbue, to issue certain guidelines regarding inadequacies and deficiencies in criminal trials versus State of Andhra Pradesh, praying therein to direct to order the opposite party to submit before the Honorable Court the records of the case as envisaged by and under section 227 of CRPC, including the records which, though collected by the IO opposite party in the course of investigation, but not being relied upon to prove the charge against the IO opposite party enforcement directorate against the applicant petitioner. While disposing the said application on 7/8/2024, the learned court below directed the prosecution to submit a report as to whether any paper document are collected during the investigation, but not relied upon on or before 9/9/2024. Now, when this order is existing, we in fact sought a time on that ground, that at least that may be complied, so that we will.
Very short on that time. In the order dated 16/8/2024, have you sought adjournment?
You have sought for a time. The court has not reflected that, and court said that either you participate in the argument or will pass an order on discharge. And that is the reason we had to participate in the discharge application on 16/8, and then court passed an order. In fact, this record is posted 5 days back. In that order also it is mentioned that the ED is yet to comply with the order. Still it is being posted for charge.
Let him argue once again.
Milord, I have to take instruction, Milord. It is the first day. Because this order nowhere says that he filed an application for time. Rather, he argued that matter. You will also see the 16/8 on the second line. The learned.
I know, the council contended inter alia summons.
In detail, the submission has been recorded.
In fact, one of the arguments, if the argument can be, because we had also said that.
Now, it's said that may be granted. At least this should be submitted.
That's the problem. Okay. Where will I get that you have really asked told the court that please hold your hands?
Insisted that if you don't press on this today, we will just
I'll take it. No,
my lord, we will.
I'll tell you. I'll take it on 14th.
My lord.
File an affidavit.
My lord.
What transfer in the court?
Yes.
And copy was not supplied. 14th. I like to stay the proceeding.
13th. 13th also more I don't know. No, 14th I have to attend special court. So 13th I am not seeking.
13 means tomorrow.
So can you
Tomorrow. Give an affidavit. Because I'll take that affidavit and then why can't you do one thing? I'll set aside this order, let him argue once again.
No, sir. I have to take instruction.
You have to take instruction, put it tomorrow, take instruction. See, there is an anomaly.
No anomaly, Lord. Unless the document is supplied, the court could not have this application.
You get 9-9 order. What happened in 9-9? Whether any document really existed or not?
My lord,
or everything is given or not? Everything is given. Why should I set aside?
My lord,
you try to understand.
6 November is
had been supplied because I was in the matter before the special court. I know your documents were supplied. Regarding this order, because I could not.
Seconds tomorrow. Come and satisfy me on an affidavit.
My lord, if 9-9 order and all the orders have to be got, then sometime has to be given.
Then he'll frame the charge. Then
my lord, then we'll file an affidavit and press on it tomorrow.
Do whatever, but satisfy me on affidavit. I'll act upon that. Mr. Agarwal will also seek it, sir. The 2 point which order is rejected.
Here we challenge the order that is 16-8. 16-8 order, there is no illegal.
Right, that is there.
He is saying order that is 7-8. That order is not challenging.
The propriety demands.
That's true. But
once you say that, let the document.
They say that that's why trial court said
see they may find out some difference out of the underlying document also.
But here, question is whether just offense under the PMLA Act has been committed or not. Admittedly, FIR has been registered.
That's there.
Admittedly, proceeds of crime has been gone to this accused.
See, these are the draconian law. There is a procedure.
Yes, no.
The procedure has to be followed.
Whatever procedure under our act, particularly we have followed.
That's right. Particularly when in a predicating offense, he was let off.
No, not let off. There are 2 FIR, not let off.
That's what he said.
No, it cannot be.
In both the FIRs, my lord, we were let off. In fact, in one FIR, we were the informant.
Even she has been let off in the civil offense.
So
the latest judgment has come. Possession of process.
You can proceed. Therefore, I am rejecting that question. You can proceed. The only thing is, if 207 is allowed, if the date is fixed, without supplying the copy, how can you proceed from the charge?
207, prior to filing of 207, they have supplied them with the document.
Nothing is coming forth.
Yes, no.
Yes, okay. Other than you seek instruction, I'll set aside. Let him argue once again.
Because in the 207, they asked that undenied documents be supplied. We said we don't have any document, undenied document. That's why court said we submit a report. So that on that.
What report you have submitted?
That I will take instruction.
If you in the report you have said no document is there, then he doesn't have a case.
My lord, if we files an affidavit in that regarding the lower court that we have no documents.
That's what he says. That is what he says. Yes. Yes.
25.
Yes, sir.
Your Lord, that time petition was filed. After issuance of summons, Lord, that time petition was rejected and invitation was issued.
The petition was on bail.
Not on bail.
Rejected by this honorable.
Anticipatory bail application was rejected.
Rejected.
Yes.
Then it didn't appear.
Yes, but in pursuant to the summon, I have filed an application for time, my lord.
That was to the summon issued by the court on 22/12/2000. In pursuant to the summon issued by Leonard James Semliguda on 22/12/2021, petitioner instead of appealing moved an application for an adjournment.
Yes.
Adjournment which has been rejected, and NBW has been issued by the court below wide order dated 5/4/2024. The letter counsel for the petitioner on instruction submits that his client would appear or surrender before the court below on 30th of November and resort to the remedy available to him under law. Regarding head to the statement made at the bar, the NBW issued by the court below wide order dated 5/4/2022. Execution of NBW issued by the court below dated 5/4/2024 shall remain kept in abeyance till 30th. So subject to petitioner appearing before the court on or before 30th of November and paying a cost of rupees 500 to the District Court Welfare Association. Koraput District yes, Bar Association.
Yes.
36.
May I please return? Let's say Belgian matter. Let's say earlier the petition was on bail. In Duly Appeal 2019 of 2019, let's say due to communication that it was a bail since 2019, let's say 4/4/2019.
4/2019, NBW issued on
let's say 22/12/22.
Yes, 22.
My lord, 22/12/500.
Okay. Next.
27.
Okay.
No, please allow. Challenging the order of NBW passed by the learned special judge Bhubaneswar, order dated 17/8/2024 and 17/9/2024.
Your Lordship, on behalf of Mr. Naik, I'm praying for a short brief. Will just file a reply, Your Lordship.
What reply in the NBW case?
Your Lordship,
Yes.
How many of you are there?
Sir, total 8 number of accused persons are there. The case was posted for framing of charge. Initially, the case was in the court of learned special judge Bhubaneswar. Thereafter, on 1/11/2023, the case record was being transferred to the court of special judge CBA1. Thereafter, since date 17/8/2024, steps have been taken through the London Council. But on 17/8/2024, there was a NBW order passed by the London Court, which was not within the knowledge of the council nor with the accused person. That is why the order of NBW has been issued.
Right. You are on bail now. The petitioner was on bail.
Yes, please.
On 23/11/2023, he moved an application under section 317 CRPC to 23 NBW was not issued.
17/8/24.
On 17/8/2020.
Yes.
On 17/8/2024, the petitioner because of the confusion, as the case has been transferred from special judge
CBA
1.
From CBA 2, it has been transferred to CBA
1 to CBA 2.
CBA 1, 2 to 1.
2 to 1. CBA, special judge CBA 2, Bhubaneswar to CBA, special judge
CBA
1,
yes,
Bhubaneswar, which led to the issuance of NBW. London Council for the Coordinator and pay a cost of 1,000 to the Bhubaneswar bar.
I'm doing this. On 17th, all the order of NBW has been issued, but your Lordship of Peru 17/9/24, it has been categorically mentioned for that order. NBW issue NBW fixing 23/10/24. Yes.
London Council for the petitioner further submits that the NBW issued on 17/8/2024 could not be executed. Hence, the same order was repeated by the trial court on 17/9/2024.
High knowledge.
1,000. Yes.
28, my lord. The petitioner was earlier bailed, my lord, on 13/6/2022, my lord. Thereafter, NBW issued on 18/9/2023.
2023,
my lord.
Okay, 500. Yes.
Yes. Grateful, my lord. Not you.
Yes.
29. May I please honor? The petitioner is in custody since 1/2/2024.
There is a case 302. It is with not with me or
All for CD. Okay. Next.
30. Specific date name.
May I please, my lord?
Yes.
My lord,
alleged offences are, my lord, under section, this is the second journey of the petitioner, my lord. My lord, so offences are, my lord, 308, 374 of IPC and 75, 79 of JJ Act and 14(1) of Child Labour Act, my lord. Yes. My lord, what are the allegation? Allegation is that, my lord, the present petitioner having a workshop, service garage, and the particular, he has engaged the informant's son to wash the vehicle in through acid. This is the only allegation. And it is mentioned that injury is simple in nature. I have annexed that, my lord. But, my lord, categorically, the informant made on stated on the deposition, my lord, the informant is Jyoganand Samal. That on para 6, he has mentioned that to his son, who has engaged his son, I cannot say who called his son to wash the acid tanker from his playground on the day of occurrence. Para 6, my lord. And I cannot say the details of the acid tanker. Para 6 of the representation 34, my lord. It cannot be said that the deal of the acid tanker. My son was engaged. I cannot say the name and type of acid. Yes.
Lordship, before going to para 6, Lordship, kindly glance para 2, Lordship. This categorically mentioned that the present accused petitioner told and called to the present.
Now I have read that.
Yes, sir.
Examination chief, you say, but in the cross examination is
discard this.
then entitled to bail. Entitled to bail. I'm not convicting him.
Another one more thing is, Lordship. Here is the infront of the father of the minor strong.
No.
Examine.
I will come to that point.
64 statement recorded by the present victim, Lordship. Victim, those that found the present informant, has not been examined.
You are in custody since? I am in custody since, my lord, 18/12/23. My lord, I am granting bail right now. Petition is accused on so and so case. Allegation against the petitioner so and so. The informant in the present case has already been examined as PW1. Who in his examination chief has stated as under. Is annexure 532. Okay. Examination chief para 2. Okay. However, in the cross examination, he has also stated as under para 6. Therefore, perusal of the evidence of the informant reveals that he is not sure as to who has in fact called his son for working in the workshop, and the source of the acid and nature of acid used used in the service center is also not confirmed by the said accused. The accused is already in custody since 18/12/2023. Regarding to the nature of evidence which came on record till late in the trial court, I am inclined to enlarge the petition on bail with the condition that the petitioner shall appear on each date of hearing before trial and shall not seek adjournment on any pretext whatsoever. Okay, so obliged, my lord. Yes.
Lordship, I am through BC Sambalpur, Lordship, Pachon Court, Sambalpur. Lordship,
Yes.
this is the second journey of the petitioner, and the petitioner is forwarded under section 457(380), Lordship. The accused petitioner is forwarded on 4/5/2024, Lordship.
Yes.
And on the earlier occasion, the Lordship, the Honorable Court directed to come after submission of charge sheet, Lordship. I guess, sir.
Custody since?
Custody since 4/5/2024, sir.
Sorry. Huh? No. Custody from?
4/5/2024, sir.
4th May 24. Okay. Yes.
We have become antecedent to earlier self-judged case.
In the Bengal.
What are the allegations against him?
Sir, as per the story,
Yes.
as per the story of the prosecution, sir, the present petitioner is working under the
Gold bangles and so on, so on, so on. Yes.
is working under.
What are the antecedents? How many antecedents are there?
Sir, I have only two antecedents, and in two antecedents, one is 274, 275, and another is, sir, in miscellaneous cases, sir, Lordship. And in between this period, Lordship.
Another what?
Related to this case, Lordship. This is a theft case, Lordship.
Similar case.
Similar case, Lordship. Your Lordship, I have annexure 5, Lordship. I would like to draw the attention of the Honorable Court, Lordship. Annexure 5. Yes. One of the accused is already enlarged on bail by the order of learned POSCO Judge Sambalpur, Lordship. Lordship.
In this case.
In this case, Lordship. I have
annexed that. What about the two cases you have? You are already on bail.
I am already in bail, sir.
Show me those cases, particularly of those cases, where you mentioned.
I have not mentioned that thing. I have mentioned my petition.
Where from you got, Mr. Vishwal, where from you got two cases, particular subject?
Petition by the SI Harsuda PS, indicating two anticipated there under section 454 and 380 IPC, and another case in 411.
You do one thing, you file an affidavit disclosing how many cases you have and what is the status of these cases. Okay?
Lordship.
Just put it after next week. Put it next week and then counsel for the petitioner to file an affidavit giving detail of the antecedents and the stage of the status of those cases. Yes. Next. Yes.
Your Lordship. I'm appearing behalf of the informant.
Yes.
And here the petitioner is in custody since 2011-2023, madam. 2011-2023.
23. Okay.
Madam. The petitioner, madam, has 6 persons named in the affair. So far, the present petitioner is not named in the affair, madam. The offence under section 302 by 34 IPC was registered. Subsequently, Chargesheet was filed under section adding the section to 120B. 120B was added. 201 and 120B, madam. 302 to 120B, 201, madam.
Yes.
Okay. The father of the father lost a fact that his son was working in a tractor manner. The owner called through his nephew and he did not come to the house manner. The affair was registered by the father manner. Subsequently, the petitioner was on suspicion his wife was arrested. The deceased having relation with the wife manner. Then, my lord, what happened, my lord?
Mr. Vishwal, do you have the CD and all?
No, filing provided.
Next week.
Lordship, I'm appearing.
Sworn to enter appearance for the informant and file Chivakaratna, which is taken on record. We can for hearing. Yes, next. 34. 33, no? 33. Yes, sir.
Alleged offence under section 302 and 301. There is no direct allegation against the petitioner. One of the similar persons have been granted.
Shall we have record?
Yes.
Yes.
On basis of the confessional statement of one Sanjay Miller, the present petitioner has been implicated, and the Sanjay himself says that this petitioner was present and he had assaulted by means of
Similar confessional statement.
Sanjay Kumar Baru.
Sanjay.
Order also there.
In Mercy, that will mention that is the accused Procedural Behera. After severe analysis, substantial arrows against the mobile number Procedural Behera conducted rate of transaction and its nearby and able to apprehend suspect Procedural Behera. On confidence, on examination and the interrogation of suspect Procedural Behera, in presence of two government witnesses, He confessed his guilty to committed murder to the Peter Ranjan Bera. He has been reflected in the
Except his confession, what do you have? Confession is not, see, accused confession is neither here nor there. You tell me any recovery, anything, any evidence you have? Confession before police. If you don't have any other evidence except that, then how many days you keeping? You just tell me, except confession, what else is there? Have you gone through file? You must go through. He recently has got the files. Let him go through. I'll put it next to him. Let him go through. Except confessional statement, anything else is there? Whether any recovery or anything?
Yes.
You read the entire charge sheet and tell me.
Yes.
Okay. Yes. Next.
Next week. 34.
No. Yes, 34.
Remain is custody since 16 to 2024.
16 to 24.
Yes, Miro. The specific allegations of murder is concerned, that is against Nirakara.
Which one you have? The file? It is not there. No, call proceeding. Yes. Yes.
35. Date may can be fixed.
They will be fixed. Yes. Yes.
35, my lord, initially 457, 380. Subsequently turned to a case, subsequently 395 added. And the present petitioner is inside custody since, my lord, 27/3/2024.
24, huh?
My lord, more than 8 months. And now already charge sheet has already been submitted. Recovery from the petitioner is two CCTV camera. Dita CCTV camera आपको recover. आगे.
Charge sheet has been filed?
आगे.
For which offences?
457, 395.
Antecedent?
Antecedent, कुछ नहीं है यार. First implication.
You started your career now. These 457 people are thinking like that only. Only 5-6 cases minimum. File affidavit. Take it on the.
Indicate. My submission not indicate.
Yes, Mr.
कुछ नहीं sir.
Covered to CC camera.
No, antecedent কথা পড়তে.
Let us see the allegation FIR. Charge sheet file? No.
Charge sheet file.
Yes.
ସେ କହୁଛନ୍ତି ବ୍ରାଞ୍ଚର ସଟର ଭାଙ୍ଗିକିରି କମ୍ପ୍ୟୁଟର
bank. What is that?
Punjab National.
ପଞ୍ଜାବ ନ୍ୟାସନାଲ ବ୍ୟାଙ୍କ
Punjab National Bank.
4ଟା ସିସିଟିଭି କ୍ୟାମେରା ଆଉ 4ଟା କମ୍ପ୍ୟୁଟର ନେଇଗଲେ ବୋଲି ଆଲିଗେସନ ଆ ପାଖରୁ 2ଟା ସିସିଟିଭି କ୍ୟାମେରା ସିଲ୍
But no money not.
ସବୁ କିଛି ନାହିଁ
ଯାଇଥିଲେ ପୂଜା ପାଇଁ bank where you choose the bank then? Bank you want, but you didn't get anything.
There are also legally antecedent. In charge sheet, it has been stated that during interrogation to above noted accused persons confessed in their confidence statement that during the year 2023, in the month of October to November,
Mr. Vishal, exactly what happens is these kind of cases, police is not able to get anything. If somebody is found, statement is taken and that is the reality. What is the reality?
young boy of 26 years.
Change you file an affidavit. Before they start confusing, you confess here. That is better. Just file an affidavit that how many cases you are involved. I'll just put it on 19th. Mr. Mishra and counsel for the petitioner would shall file an affidavit for the petitioner regarding the antecedents. Regarding the antecedents on 19th. File the affidavit and take you can record that and I'll grant it.
36.
May I praise the Lord, Simala. Here, my lord, petitioner is languishing in the jail question was 16/12/2023, my lord.
16/12/2023,
my lord.
23, okay.
Here, my lord, the lordship turned to page 11, annexure 1, the petitioner married to the
498.
On 14/2/2025. Chargesheet file.
And 6.
No, my lord. Here he has lodged an affair. 2015 she has taken care of some relationship. In 2015, thereafter matter was settled. Got married in 2023. Thereafter, my lord, they gave a first cause of action in the year 2000. They are trying to kill the my lord.
What is the medical use? Show me.
And your lordship has also directed for interim bail. Petitioner has also got interim bail, tried to sort out the dispute. He is not interested to stay with the petitioner, my lord. I have not violated any terms and conditions also.
When is that interim order?
My lord, on 14/3/2024. And custody my lord 16/2023 allegation ଟା କରିଛି ତାପରେ
That's right, but where is the show me the interim order?
14/3/2024.
In this matter?
In this matter.
You have surrendered, huh?
Yes, my lord. I was not violated any terms and conditions, my lord.
Yes. Grant bail, but right now. Petitioner is accused in so and so case. The para 1 and 2 meter. Para 1 and 2 meter. Earlier the matter was next para. Earlier the matter was taken up for hearing. It para 3 we got give. Para 3 got give. Para 4 we got give. Para 4 to karo. Para. By the order dated, taking into consideration the aforementioned, on 14/3/2024, the petitioner was granted interim bail for a period of
6 weeks, my lord.
For a period of 6 weeks. Also, you also there.
And 2015 ବାହା ହେଇଥିଲେ।
Within 6 weeks, nothing happened.
No, my lord, I have tried my, she is not interested to stay with the petitioner.
But what will happen to this girl?
My lord,
you are married.
No, I am not a married person.
I mean, you are married that girl.
I am also.
You married that girl. That's what you said in the last.
Yes, my lord. I am also interested to keep her, but she is not interested to stay with the. That's why I have tried my level best, my lord.
The petitioner granted interim bail for 6 weeks, so as to explore the possibility of reviving her marital life and live peacefully. Live peacefully with the opposite party victims. The petitioner has already surrendered.
Yes, ma'am, surrendered.
When?
My lord, in the right time, my lord. During the time.
After the expiry of the interim bail period. The counsel for the petitioner submits that within these 6 weeks, during the interim period, he made all efforts to see that the marital life for the petitioner is revived. But he could not get full success. Full success. Full success. He further submits, Mr. Banjadev further submits that petitioner is already in custody since 16 to 12 2023. Trial has not yet commenced. Therefore, he seeks indulgence of this court for grant of regular bail to him. Regarding head to the sequence of event unfolded in the present case and nature of allegations, I am inclined to enlarge the petitioner on bail with a condition that the petitioner shall keep on making efforts to settle the dispute with the victim girl as he has already married with her. It is also expected that the trial court shall do well to see that the victim is examined preferentially over all other witnesses. He shall be released on bail with conditions also. Let us see what to do, or nothing can be done. No, 88. We see.
Item of 2 and 45 after my review asked for adjournment. It didn't pass over. After laws, I
You may not, I noted down because the other side lawyer was not there, therefore I noted down.
Both the cases are not because there's no other side cases. You have one side state is there. Item of 2 state is there.
No, something is there. I wanted to dismiss it seems.
As far as next week, is hearing for them. That may can fix at no objection.
I might have seen that there must be nothing on this matter. Therefore, I.
Because it is there.
Okay.
It is there. Next week,
See, please don't ask for the times. Okay. The main problem is I am trying to adjust all the matters. Matters are listed. If you ask for a time, it there is the cost of other people those who are standing. So, but what I do is anybody will ask time, I impose cost.
Next week, I assume to argue this material.
40 memos are there. But if you would have not asked for the adjournment, at least one matter could have.
More time, I I'm telling you, 45 minutes, 2 and 45.
700, 800 matters are not heard once. 45
So, मैं आज तो आसना सुबह सब्जेक्ट होता है
ठीक है रख दी
The
problem is a lawyer of your stature comes and asks for time, I have to give it. That's the whole difficulty. But in the same time, the court is expecting that lawyer of your stature should not come and ask time. At the same time, this is the expectation from the court. Anyway, I'll communicate after 2 weeks. Yes.
Item 53.
Any
Item
yes.
53, man.
Yes, sir.
I am entering appearance today.
For opposite party?
For opposite party number 2.
Entry order is there?
It's no, my lord. It's for question of FIR, man.
Yes. So and so enters appearance on behalf of opposite party number 2. Files Vakaratnama. The same is taken on record. Release the matter. Okay. Yes. Any mentioning? No.
Anything.
Okay. Thank you.
Which is out there, this is also slowed down.
difficulties are there, but you can find out the.
See, the problem is, when you understand, if you don't need the achieve, that time it will be work out. When the achieve required, it will not work.
Anyway,
We are the procedure. I'll see. Lunch hour, I understand, lunch, that's the time when you work.
For that, two fans will arrange by.
Sound rate. They create smoke sound. I know. You make it sure that, I'll make it sure that. Yes.
In fact, this is a submission on behalf of all my colleagues.
Yes, I understand it. I'll make sure that things will, yes.
37.
Yes. Under the this is the second round, my lord. Earlier application, the petitioner approached this only court, my lord. While disposing the,
in the first round, you are with that side. Second round,
yes. But in this case, my lord,
yes.
the lordship, while disposing the earlier bail application, mentioned in paragraph 4, my lord, that is BLAPL number 410-2024, my lord.
Where is that you have placed it?
Paragraph 4, my lord. Paragraph.
Yes. Yes.
Your lordship specifically stated that after examination of two of the witnesses, my lord, namely Vinod Kumar and another, my lord, Surendra.
Yes. They are examined?
Or they have already examined.
Yes. Yes, I got it.
That is there, my lord. Pidol 8 is the Vinod Kumar and Pidol 9 Surendra. Surendra declared hostile, did not support the prosecution case, but Vinod somehow supported the case of prosecution, my lord. But
no.
Specifically, my lord, Vinod Kumar and
Vinod and
Surendra. Vinod, my lord, examined as Pidol 8 and Pidol 9 is Surendra. One is supported, another not supported prosecution case, my lord.
The witness who was supported, let us see.
Pidol 8.
Okay.
PW7 and PW on the basis of PW7 and PW8. They have not granted bail. And with the PW9, even though hostile, but supported in cross-examination, supported.
PW8, let us see. PW8. How many witnesses are left now?
Total 34, my lord. Out of 34, 9 had already examined. Specifically, also director earlier application.
Yes,
given liberty.
So many Vinod,
my lord. Vinod, I know informant. Pidol 7, my lord. She is not an eyewitness to occurrence, she is the wife of the deceased, madam. She is not an eyewitness to occurrence. Pidol 7, examine. Informant examined Pidol 7.
I would mention that Vinod Kumar.
Vinod and Surendra.
No, what Vinod says,
madam. I know this is victim Khirot Kandia. I know the accused persons, namely Premanand Bhoi, Premchand Bhoi, petitioner 1, madam, and 2, Premchand Bhoi, alias Kana, Gyanaranjan Behra, petitioner 4, madam. Second paragraph. Gyanaranjan Behra पढ़ते Gyanaranjan Behra, then Rohit Pradhan, Suraj Pradhan para petitioner 2, Rohit Pradhan para petition number 5, Neeraj Pradhan para petition number 3, Subrat Behra, petitioner 7, Hemsagar Pradhan, petition number 8, Runala se Lalit Body. Though he had named as Sibo Somanath Patnaik. He has totally know these accused persons.
Yes.
But in fact, paragraph 2, the incident took place in between 10 a.m. to 10:30 a.m. in the morning of 16 September 2023 at Uparpeda, Kontapalli on 15/9/2023 in the Labanna Hotel near Kontapalli during daytime. Accused Raja, that is the petition number
yes,
7. Raja, alias Subrat Behra, abused the deceased victim Khirot Kandia by addressing him as
so
before the presence inside the said hotel on 16/9/2023 at about 8:30 a.m. In the morning, the deceased victim, Khiro Tandia, told me, and Jogesh Parik, another boy of Hon'Ble, whose name I do not remember, about the incident of previous day. Then myself, the deceased victim, Khiro Tandia, Jogesh Parik, Babu, and the boy of Hon'Ble went to the goddess Puja Mandap of Upperbeda, Kontapalli. But they went to near the house of the accused persons, my lord. After our arrival at the spot, the deceased victim Khiro Tandia called the accused Raja, Petition 7, Subrat Behera, and asked him as to why he was addressing him such an unusual. At that time, Niraj Rohit, Sibo.
Yes, you tell me the number of which petitioner is that at that time?
Niraj is there, madam.
Number?
Niraj number? Petitioner 3.
Okay, Niraj 3. Yes.
Rohit. Rohit 5, madam. Petitioner 5.
Yes.
Niraj. Sibo. Sibo, madam.
He is petitioner in item 39.
Sibo in item 39, madam.
Yes.
Kanha, madam. Petitioner 1. Suraj petition number.
Kanha is 1.
Kanha the petitioner number 1.
1, yes.
1.
Suraj.
Petitioner 2.
2, yes.
Jnana, petitioner 4.
4, yes.
Jaddu, petitioner 8.
8, okay.
He has not stated name of a Tunna alias Loditi body. Not name, madam.
Petition number?
6.
6 is not named.
Not name is name of petitioner 6. Tunna.
All of them have Then
all of them attacked. Then all of them attacked the deceased victim, Khiro Tandia, and assaulted him. Upon seeing this, I, along with Jogesh Parik and the boy of Hon'Ble, ran away from the spot in fear and stopped at a distance about 20 to 30 feet from the spot. While standing there, we saw the accused Raja
7.
Madam. Alias Subrat was armed with the knife. Accused Niraj, Rohit, Sibu were armed with the bamboo lathi. Accused Kanha, Suraj were armed with the plastic pipes, and accused Jaddu and Jnana were armed with the bricks bags. At that time, we saw all the accused persons assaulting the deceased victim Khiro Tandia with a weapon held by them. Then all of the accused persons through motorcycle.
Okay. 6 I will grant you.
No, madam. What happened in this case, madam? What happened? One thing, madam, I beg somebody, madam. If this madam witness present at this spot at this time of occurrence, this spot, madam, the another witness here, madam, not supported the procedural case, madam. Basing on the madam statement, madam. Prior to that, after madam, he seen the eyewitness. He seen the incident. No doubt, he seen the incident. But in fact, madam, what happened, madam? The FIR was after the death of the deceased, madam. In the FIR, madam, name of the all of them not there, and the informant not stated anything about the pedolate, madam. That a pedolate seen, madam. Why he remains silent, madam? If he seen the occurrence, madam, why he remains silent? What Surendra say? Madam?
Surendra is not supported.
Yes, madam. Surendra, madam. Surendra Behera, I do not be
50.
For the 50. Yes.
It is not the fact that I had stated.
Leading question.
Not a fact.
Not a fact. But Surendra not supporting the case, my lord. And other petitioners are all are students, my lord. Some of the petitioners are students, my lord, 19 years and then 42 years. There are prosecuting that.
Come to para 15 of Surendra. He has also taken the name of these people.
15 madam.
Raja Behera.
15 madam process by the prosecution, madam.
He has taken the name. Just see Raja Behera, Neeraj Pradhan, Suraj Pradhan.
It is not a fact, madam. It is not a fact, madam.
It was put to him.
Put to him, not a fact, madam. That cannot take into consideration, madam.
So let 6 get the bill first to begin with. We'll see.
Another 3
6 name is not taken. He was not particular.
In fact, my
eyewitness has not said anything about it.
What I beg to submit, my lord, though there are, my lord, 40 injuries on the part of the body of the deceased, my lord. Injury number 29, 30, 31, 32, 34, and 39
And my lord,
See these witness, then you have to give me detail regarding what are the weapon carried by these people and corresponding injuries.
my lord, injury, my lord,
Injury. Give a chart. I can't read. Postmortem report and number of injuries and corresponding weapon seized from them and corresponding injury.
and let's see column number 4, my lord. And most of the injury in knife, my lord. One person holding knife, my lord. That's that. It looks like, my lord. Most of the injuries, my lord. Cut injury and stabbed injury.
Wow, so many injuries.
40 injuries are there, my lord.
40 injuries.
My lord. In fact, these injuries are, but I have stated that these injuries 29, 30, 31, 30, 34, 35, 36, and 39, my lord. Most of the injury caused by the sharp weapon, my lord. That is knife, my lord. One person holding knife, my lord. And no specific overt act against any specific overt act against any specific allegation against any of the accused persons.
Stab injuries.
Only because that person, it was person number 7 holding the knife, he might be counted the knife injury there, others, their students, that may be considered.
Total the injuries, corresponding injury, there is nothing, no opinion is,
These are the injuries of the hotel, my lord.
What are the recovery? Weapon? Only everything is recovered. Just check it up and tell me. Let him check it up. Yes. After 2 weeks, 6 you have entitled. Shall I grant 6 and you go and repeat your bail application so for other circles?
Once I will take another chance, my lord.
6, I think entitled to be.
Also check them. Also say that. Better amount charge कर दो.
Charge बना.
Little better होता है.
Very difficult. Yes.
Made visual custody 23.
How many bail?
23.
Bail is. Yes.
Custody 38. Custody 23, 2024. On the allegation of 38, 2023. On the allegation 23.
Custody?
23,
Okay.
on the allegation, my lord, transporting of my lord, Ganja 60 kg of Ganja, final form submitted, and I am submitting, my lord, the final pair as well as the no criminal antecedent application. And earlier occasion, my lord directed to me, remove stage, my lord, only my lord, charge them, no witnesses, and last occasion, my lord, earlier occasion, while disposing of the application, people liberty petition, remove. That is my lord.
CD is not there. See, recovering 60 kg of ganja. 1 year he is already in custody. No antecedents. But charge sheet has been filed. Generally, less than 100 kilos. Generally, 1 year, 100 kilo. Generally we give. But after CD only. After 1 week, CD call for.
CD.
Without CD is not. And by way of last chance, the Vishal is granted 1 week adjournment for obtaining CD. It is made clear that if the CD is not obtained by the next date of hearing, the matter will be resolved on the basis of the material available. Yes.
Right.
Hello, not the same. I am a co-accused. So-accused, your name is also taken. You are the king of a name. Can that be sufficient? My submission is this. Your lordship is on
Besides, the name, the eyewitness has not taken name of one of the accused. I will also ask
Has not your lordship to find out?
That I'll just see. I'm there. You are in custody since?
I am in custody since 12th of January 2024.
24.
Yes.
Oh, at least 1 year you should be there, madam. Nearing 1 year, if not 1 year.
That is what I was also thinking, Lords, that when these new acts were enacted, they should have inserted a proviso that consideration for bail should arise only after somebody is in custody for a year or so.
1 year,
What about the prevention of innocence that benefits? What about the law that your lordships have been laying down that bail should not be refused as a measure of pre-trial punishment?
see, the rules are otherwise, sometimes we grant bail, Supreme Court says that why are you granting bail? Sometimes you don't grant bail, Supreme Court says that you are not granting bail. What to do? And the same thing we are doing with the ideally speaking, bail should be granted.
Ultimately, who suffers?
Ideally speaking, see, we are not consistent. With respect, we are not consistent in our own view. Own views. Because see, there are 40 injuries. And nothing is coming very clearly. Who has given which blow? And corresponding injury, if you see with the medical report, things are there. At least on that basis, somebody is entitled to bail. I'm not saying that it could
Let us visualize a person is being assaulted by, let's say, even 8 people in the laws who are surrounded him and he is falling. But is it possible for all these people to assault, and is it possible for the witness to see who has assaulted?
I know, of course, see, meticulous, taking bail, meticulously, saying that he has done this, but it's a key. When somebody is attacking, and eyewitness is definitely to be perturbed. We can't remember everything, who is sending blow, what kind of blow and all. That meticulous narration of that itself is doubtful. That itself is doubtful. Conviction and the evidence is something different. But the popular bail, at least we should be one week. Prepare a chart, let us see what. We'll try to find out who are at least entitled for the
There's a small book, Millers, evidence for law students, written by Mr. V.P. Sarathi, senior counsel. If your lordship should read the prologue to it, just 4 lines. What is true? Asked Justin Pilate, and he waited for an answer.
It's very difficult to reconcile the situation. Very difficult.
Yes. Yes. Petition in custody since 1/7/2023. 1/7/2023.
Okay.
Earlier, this present petitioner had approached this Hon'Ble court. That is before submission of charge sheet.
Charge sheet has been filed?
Yes. Order is at page 40. 40 annex 3. My lord has indicated that. Yes. Since charge sheet has already been submitted, you approve the past court.
Yes. Where is the charge sheet?
The charge sheet included, I have filed charge sheet under annex 2, page 23. Starts from page 23.
Yes. 302. Yes. Yes. What are the allegations?
The offense is 364, 302, 201, 120, 34 IPC. Therefore, there is no eyewitness to the occurrence. On the basis of 27 Evidence Act, what is recovered? Dead body as well as your gun. That has been recovered from a court, not at my instance, not from my position. On the basis of court statement, under Section 27 of the Indian Evidence Act, I have been implicated. I am in custody since once.
The 27 is invoked for that accused.
That malady will find, that evidence malady will find, is 47 of the impugned order.
47.
Page 47. This is the impugned order, page 47.
Yes.
The 13 line from top. 13 line from top. Yes. Page 47. Starts from the accused Rajit Krishna. Malad got it?
Yes.
Yes, really. But actually, Vajit Krishna further concludes that when the supericular V. Rajesh Raja went to Visakhapatnam, the accused Vajit Krishna killed him in the forest of such and such wildlife sanctuary near such and such in the night of 19/6/2023 with the help of such and such persons. That means I tend to picture you. I myself is Govinda alias Sikke alias Kannan.
He is the brother-in-law of the person.
The connected matters are pending. Your Lordship, I was just going to bring that very fact. Lordship, the other 4 bail matters have been fixed for on 12th. Lordship.
Exactly. 14.
Yes,
14.
No. Okay. All the connected matters.
Because I remember this is super equivalent. Money is not going to who was that.
Out of 30, quality of the offences really is very.
I know. Yes. Yes.
Extremely disturbing.
Yes. 41.
41.
Yes.
I will permitted to place on behalf of Mr.
Yes.
It's a case where earlier it was there because of the fact that charge was not submitted, but I have directed me to come only after some charge sheet. Again, after some charge sheet, I move.
What is the recovery?
But recovery so far that part is concerned by Hon'Ble solicitor, the outside is save and except poetry statement. I have no materials there. As for the prosecution case, they got information, they found some copies of it. Some poetry were arrested, about seven in numbers. This occurrence was allegedly on 25/3/2023. So 24. And in all that statement, the petitioner was not present in the spot, so his role was not there. And one of the accused said that petitioner has associated by the process, he gave some money for the particular purpose. And with this statement, petitioner was arrested about after a month. So no recovery.
What about the other? Rajesh Nag and
I'm appealing my lord.
Ravidas,
Rajesh Karma Maji and Rahul Nag, my lord. 3 petitions are there. Then BL 10487, my lord. You also earlier when approach, you also directed him to after some charge to move.
Yes.
What happened is actually, my lord, what happened? 5,520 bottles of cough syrup, my lord, seized. And total codeine, my lord, 1 kg, 104 grams, my lord. That is recovered from the court, my lord. This petition was my lord, implicated in this case, based on the confessional statement of the court, Pinky Meher, my lord. Pinky Meher, my lord.
Pinky Meher.
Who are present at the seizure, my lord. And from his, and all from Rohan, Rajesh, and Ravi, everybody is implicated based on the basis of the statement of Pinky, my lord. Who was arrested from the spot? Pinky? Only Pinky. Pinky was my lord. Only Pinky. Pinky, all the people were arrested completely. Pinky confessed later the petitioner. 7 persons, my lord. 7 persons, my lord. And Pinky confessed name of this, my client's name. Who was apprehended from the spot? The lordship may kindly have a look. Lordship, all the bail petitioners have got criminal antecedents. 21 cases pending, 8 cases pending, 3 cases pending. Now, each and every one of them are in the business of those dealing with those kind of contraband substances. All of them. Yes. 21 cases, 8 cases.
My brother is forgetting the export judgment. Well, each case stands on its own lane. Merely because I have some case, it doesn't require to be considered.
You will file affidavit. Disclosing the number of cases you have and what are the status of them.
That's the state council has also.
You file, I want that you should file. What the number? You may say whatever. If you have numbers, then all the cases will take affidavit and take it on the then I on the merits of see, I'll tell you, antecedent is one thing that will take care. And if they have antecedent, suitably the condition has to be okay. This is one thing. Second is, if they are not arrested from the spot, conscious position, you can't include from conscious position. So at least they are entitled for bail. Conviction or no conviction, I am not interested. So therefore, let us see what kind of cases accordingly we will impose the conditions. What kind of condition has to be imposed? You just tell me. Lordship, regarding the spot of arrest, I have to take instructions. Yes.
Chargesheet is there. That is the
Chargesheet. Yes. Okay. What did
Take it on 19th will file in winter.
19 will be heavy. I just suggest within that we can do. Yes.
My lord, give me a date so that we can.
Yeah, date we will give, don't worry. I have 5, 6 not about 10, 15 matters. Tied up matters? Total? Only total. Not today. The total only maybe 20 matters maybe. I want to finish it up. This is where that will be. This is coming along in progressing on the.
So, yes, madam. In some cases where Malad can get
It's guaranteed to
the adjourning.
That's what. Yes. Yes.
Coming with Malad.
Lordship, in item of 42, CD is not available. TD, call for CD. Yeah.
May please, Your Lordship. Your Lordship, I
TD.
am on item 42, Your Lordship. Last occasion, Your Lordship, and Your Lordship kindly visualize this.
CD, when I think.
Your Lordship, that is the second round litigation. In the first round litigation, three times were given, they were not provided CD.
There is a change of guard, give an opportunity.
Your Lordship, may say that this is the last chance, Your Lordship.
Was listed. It was on the board. Your Lordship, I call for second of 28 times. You call for it. Okay. Next.
43. Your Lordship, pay fixed short date.
He's giving sir. 43 my lord, similar to 21. Then we give next week on the 43 my lord, same case as 41. Maybe lifted on that date. Yes, 41. Yes. 44. Somebody asked for adjournment 44? No, 44. Lordship, item 40. It has come up. Review. So it's a review petition, Your Lordship, filed by the state. Yes. Seeking a review order dated 14/3/18 of this honorable court. Yes. Lordship. Lordship may kindly have a glance at page 18. Lordship. 18. Okay. This case number 287. Yes. Yes. What is wrong, Lordship? Para 2, the Lordship. As provided in section 24C of the Orissa Education Act, the appeal has to be preferred within a period of 60 days from the date of passing of the judgment, and not from the communication, as the said concept of communication has neither been mandated in the Act nor in the rules. In the instant case, the judgment had been passed on 21st 2014. The memorandum of appeal before this court has been presented on 22/3/2016, and it is after a delay of 732 days. I proceed, Your Lordship. Yes. Lordship, then it is stated. First of all, it is stated. Delay is not random and dismissed. Your Lordship. How is it maintainable for that? Non-convention of delay in entertaining a fee, Lordship. If it is dismissed, how will you maintain a review? Who is not maintainable? You reach out to everybody, you know. Most what generally is relied upon. Yes, sir. The petitioner preferred petition is agreed by the in this review petition is agreed by the order dated 14/2018 passed by the learned single judge of this honorable court in Miss case number 287 of 2016 in FOA number 147 after 760. The Miss case moved by the state for condemnation of delay in filing the first appeal has been rejected. The single judge was not satisfied on the cause shown to explain the delay of 732 days. Therefore, relying upon the judgment of the Honorable Supreme Court reported in 2012 3 SEC 563 of Office of the Postmaster General and others versus Living Media India Limited dismissed the application as a consequence of as a sequel to that the FAO as a corollary to that the FAO also failed and was dismissed. Failed and was dismissed. Against the said order, the petitioners have preferred. The SLP also dismissed.
Lordship, SLP was not filed.
What did this order then? 23.
Lordship,
Ajay Kumar Vera.
Yeah, Lordship. It has been cited
SLP
as a precedent.
preferred review petition. Review petition relying upon the order of the Honorable Supreme Court in one of the matters. Relying upon order dated 1/9/2017 passed by the Honorable Supreme Court in civil appeal number 11180-81 of 2017. The Honorable Supreme Court in the similar circumstances have passed when account for the petition submitted that the Honorable Supreme Court in the similar circumstances will condone the delay and pass the following order. Page 24. Paragraph. The condemnation of delay and allowing the appeal to be heard by the High Court passed by the Supreme Court is based on the facts of that case. And the petitioner is not able to convince the court regarding the number of days delay in those cases in which the Honorable Supreme Court had condoned the delay. Moreover, the judgment, moreover, the sufficient cause to be shown to explain the delay being a pure question of fact has to be appreciated on the basis of appreciated on each individual case. I am not convinced by the argument put forth by the petitioner in this case, hence the review petition fails. Accordingly, it is dismissed. Yes, sir.
Yes. 46.
My lord, small term, my lord. For my lord.
Yes.
My name may be reflected, my lord.
In that matter,
You also dismiss the matter.
you write down his name also. Appealing for the petition.
Response.
Yes.
My lord, you dismiss my lord.
46.
Yes, sir.
Forty-six.
Yes.
When I was on page 1.
Page 1.
Let's check.
Are you referring to
Yes, that is
okay.
On 23/11/1993. So we have for the gazette notification, staff selection, Orissa staff selection commission member. Thereafter, on 19/1/2094, staff selection was cancelled at my lord Qatar. On 11/12/96, the petitioner was appointed as a junior typist in the office of Orissa Staff Selection Commission on ad hoc basis 44 days.
Yes.
That is whether I have annexed page 10.
Yes.
Thereafter, 28/7/1997.
This petition, yes.
This is fast happening.
Yes.
96. On 28/9/97, the Secretary Orissa Staff Selection wrote a letter to the GA department regarding the appointment of junior typist in Orissa Staff Selection Commission by the section such. Was in annex to annexers. Page 11, tangible. Page 11.
Yes. Page 11. Yes.
Here in this letter, the commission was quite
asks for to depute a typist on regular basis.
Regular basis.
Thereafter, your lordship can have to page 12. Next question.
Where does it define regular basis? Filling up to the.
No, there is no regular manner. Appointment was made. He sought from the secretary member to appoint a regular basis typist in the organization.
Okay.
Therefore, the Home Department may please be intimated to sponsor one typist for appointment as junior typist against the post of senior grade typist.
Okay.
Thereafter, my lord, in next page, madam, page 12, madam, the Deputy Secretary to Government, madam, it is therefore requested that the qualified general category candidate may be allotted to the Commission for appointment of junior grade typist in the office of the Odisha Subordinate Staff Selection Commission for
Yes.
under information.
Yes.
Thereafter, next page, madam, 13, madam, also initially, madam, there is a senior typist. But junior typist it was also under record on 2012-1997. At that time, the petition was like
Continue.
on 44 page basis.
Continuing process to the first order, that is
Yes, madam.
96 order.
44 days, madam, gap. Yes, 1 day gap, thereafter publication. Thereafter, madam, since I agreement that some after that, madam, 2 years, madam, elapsed. They are not regularized. I apprehend that they may, from this letter, madam, I apprehend that someone will be appointed. So I know way.
Yes.
Original application, and it's page 15, madam.
Page 15, okay.
Madam.
What is
But, it was, madam, admitted, and I'm interim, madam. It is a conditional order. Well, that's paragraph 2.
Yes.
Page 15. Now, remember, as regards the interim term, if there is necessity for naming the post, forms are available for paying his remuneration and work is available to keep him fully engaged, then the applicant be allowed to continue in the post of junior grade type till 31/12/1998.
98.
Thereafter, it was absoluteness.
98, you what? Yes, under this. That means two inference can be drawn. One is remuneration, it was available, and we also refer to therefore you continue. Okay.
So that order, that engine order that was on 34/1999 until further orders were made.
Until further order. Yes.
Thereafter, what happens, my lord? I have continued.
Yes.
In the 2002, my lord, they have not paid my salary. Though I have continued, I have again you file to make, my lord. Again, my lord, after filing of that, issue notice, and after filing of the my lord, they have an annex to 1 page 18, my lord. On 27/1/2003, my lord, current salary, my lord,
is revised scale based will continue without further delay.
not delay.
Okay.
That paid, my lord, 2003.
Okay.
Thereafter, my lord, on 2003, I have continued since 2012.
Yes.
In the, I have annexed all the documents, my lord, of my appointment, 44 days, my lord.
Yes. All these continuous.
My lord, continuous since 2012.
Yes. Yes. All these orders.
All these orders.
All these orders. Yes.
On
the last was 2022.
no, my lord, on 4/4/2012, my lord. At page 75.
75? Yes. Yes.
What is?
4/4/2012.
4/4/2012. Then, my lord, there is a clarification regarding payment of salary to object works. That is Also clearly written that immediately improvement passed by the tribunal, if the work and form is available in that case, taken into consideration the past service rendered by the petitioner, this case may be taken into consideration and he may be engaged to discharge the duty and respectfully assigned to mine.
But on 30th September 2022, it says since two new recruited junior stenographers have been
that is
joined,
yes.
there is no necessity of having another.
That is stenographer. I am typist.
Typist.
There are different posts. It was for typist.
Okay.
And in the other manner, civil judgment have passed that
You are claiming for junior typist only.
only
Okay.
and I am continuing from the and you will see Uma Devi, there is one line in the Uma Devi, para 58. But 44 actually, if a person continuing by virtue of an interim order, he shall not be considered manner. Here, not a interim order, it is a conditional order. If work exists, if remuneration, if fund is available, then you continue. Since I am 2022, I am 55 years. At this stage, my life.
But what the Leonard single judge said?
Single judge has stated in the here, I am not continuing in the petition.
Where is that?
Paragraph 4, my lord. 4, my lord.
Para?
4.
Page 4 period.
Interim order.
11/10/2022 order, my lord. Of the
11/10/2022.
My lord.
What happened after 11/10/2000 when you were
After passing of this order, the risk is we are not continuing.
Yes. Para? Which para?
My lord, Mr. Rao, paragraph 4, my lord. So the Lord counsel for the petition that though the petition was continuing service, but he was not allowed to discharge the duty. Therefore, necessary direction may be issued to the opposite party, allow the petition to discharge the duty in compliance of the order dated such and such, passed by the English. Mr. One additional advocate such connect that no the tribunal has to for continuance of the service order, therefore relief from the IO cannot be having regard her
contingent. Nowhere the tribunal has directed the continuance of service of the petitioner. Therefore, also. And what is the finding?
Finding last para next page, page 13 manner. On 13th of 1999, the tribunal extended interim until further by the time such order passed. The petitioner was in service since there is no establishment, no funds were allowed there to allow the petitioner to continue in service. Therefore, the order tribunal cannot be implemented. As a consequence, the Secretary of Orissa, the High Order dated engaged the petitioner junior grade as a level 4 on 90 days with usual due as for 44 days with effect from 5/8/2022 to 17/9/2022.
नहीं para 6
para 6 मतलब last para
first
having heard long counsel for the parties and after going through the record, it appears the tribunal has passed this order in 2/12/19 with the following observation. As regards the interim order, if there is necessity for managing the post, funds are available for paying this remuneration, work is available to feed in fully engaged. Then the application be allowed to continue in the post of junior grader till 31/12/1998. May this will be listed before this date and on the next date either counter be filed and submission made as to why the interim order shall never be subjective order.
Never is subjective order. There are three.
Finding that only I am since 99 manner 34/99 after 34/99 I was not in service and I was in service for last from 5/8/2022 to 17/9/2022, only 2 months. For that reason, there is no continuous service.
That is, for that reason, I have filed that review.
How will you deal with it?
I have
The finding is after 30th of April 1999,
My lord,
you have not been continuing.
I have said the annex that document in my all the documents, my lord.
You continue.
My lord, continue.
Was that the part of the record?
Part of the so 1990 ସେଥିରେ ନଥିବ କେବେ କାରଣ ମୁଁ ସେତେବେଳେ କଣ୍ଟିନ୍ୟୁ କରୁଥିଲି ଆଉ ଏଇ ଡେଭଲପମେଣ୍ଟ ଗୁଡା
What he says in page 13, the last paragraph, which is made the basis of the dismissal of his petition, the factuality is wrong. There is an error on the basis of this document. So therefore review.
We take instruction.
These documents which he is relying upon, these documents speaks otherwise. He continued up till 30th September 2022. But the finding of the court is after 30th April 1999, he is not continuing.
He has not continued.
That's wrong. See, he has filed all these documents.
Sorry. Take instruction.
How much time will you take? You have this.
No, I am giving you a copy. I am giving the copy.
If this is the case, then it is a case for review. This is a case for review. I'll review it and for hearing again, I'll keep it. Writ petition, divide the writ petition, keep it for hearing once again. Okay. So you place it on record.
But I have filed before the next week.
Better place it on record. Let it come on record.
So after 2 weeks.
But you seek instruction. If that is the case, then these documents has to be taken into consideration. The document was not taken into consideration. So therefore this finding has come. This finding is contrary to the reality. I have asked a very specific question whether these documents were there before. Therefore, the document has to be taken into consideration and it is upset this finding. And it will be heard at its way. What is the worth of this document will be considered by the writ court. Somehow this order will go. Shall I set aside and put it?
Lordship, let me take instruction regarding.
Okay, after 2 weeks. After 2 weeks.
47.
I am recording. It's better recording. Right on. Mr. Tripathi, let me make a query by has hands up for the bunch of documents on the basis of which he could successfully demonstrate that the petitioner has been continuing as a junior typist up till 30th September 2022. A series of documents have been relied upon to substantiate this system.
সেটা রিট আপিলে আমি সেটারে উইথড্র কলু হাই ওয়ার নট ফাইল রিভিউ ফর সেটা লিবর্টি দিয়াছি আমি সেইটারে রিভিউ ফাইল আমি সেটা রিভিউ ফাইল
Rit appeal
মানে আই হ্যাভ ফাইল চ্যালেঞ্জ দিস অর্ডর মানে then আমার honorable chief justice has stated that you have to why file a recall, we have filed a recall that was rejected and we file writ appeal,
then he will say file
review further then I file a review. What's your review?
Substantiate. He is also, Mr. Tripathi pointed out the findings recorded by the learned civil judge in the impugn order, which impugn order, which means that the honorable learned civil judge has non-suited the petitioner on the basis of the basis of his finding that the petitioner was not in employment after 30th April 1999. The relevant paragraph of the findings recorded by learned single judge in the impugn order dated 11/10/2022 is reproduced for ready reference. Page 13, that is on 30th for 99, the paragraph. The paragraph, only see that paragraph. Legal counsel for the state submits that since the documents are filed today, he would be seeking instruction in this regard, and ascertain as to whether the petitioner was indeed petitioner had indeed continued in the service beyond 30th April 1999 or not. Issue notice. Notice has already been issued.
No.
Issue notice. Written note so and so. Up to 3 weeks. Yes. Up to 3 weeks.
Okay. Adjournment party staff selection commission. Whether my government will take notice or I have to take notice.
Special panel.
There is a special panel.
Special panel are there.
Now, who all are the party? 40? Yeah,
Party staff selection commission. State of Orissa and others also.
State of Orissa. This is item number 46. So he is working. He was working where? Which department?
Staff selection commission. One of the staff selection commission.
Oh.
Orissa staff selection commission.
Chairman Orissa staff.
Minor.
Let him
take instructions.
Take instructions and issue a fresh, separate notice to opposite party number 2.
Yes, sir.
For opposite party number 1, he will appear. For opposite number party number 2,
and take
out notice.
Minor. By
registered. Yes.
Sir.
I think it had a rate of appeal. Rate of appeal. 21/4/2023. I checked up the case that is it find that the state government has filed against Harihara Behera. Here is the Ajay Kumar Shah.
No, it a rule number.
You check it up. I'm just issuing notice. Let us see.
This restoration petition has been filed for non-appearance of both the parties. And I have filed the petition and delay is there. So notice is to go.
How much delay? How much delay?
1 year and some days. That is 11/8/23. No, both the parties. Generally, civil death of civil cases now it is in Orissa High Court. So that for years together, and from the order, it is very much clear. I have argued the matter for 5 years judgment reserved. Once 2 years I have argued, twice or thrice I have argued. And judgment was reserved. Again, the judge used to transfer or take retirement, then thereafter. And both the parties were absent. It may be, I shall serve the copy on the counsel A. Mishra, so that it may be restored or notice will go another 1 decade it will go. It is a matter of 84.
Do you have a case on merit?
Yes. I am for the appellant. And now additional evidence I filed that has been allowed from the order sheet also there is mention and some.
Why issue notice? Because the delay.
Yes.
Issue notice. Issue notice.
Post requisites within 3 days.
Within 3 days, okay. And give it data after 3 weeks. Okay.
48.
Lord, I filed an interim application for modification of the order dated 8/10/24, your lordship. 8/10/24.
Yes.
Where my lord, the name of the father of the petitioner was wrongly reflected as Shamo Khora alias Shamo Khora. It will be, my lord, Shamo Khora. Shamo Khora alias late Madan Khora. Along with the said, I have also filed a consolidated cost title.
Where is that?
I think it was in
in the impugn order, sorry, in the order granting you bail.
Yes.
Father name is not there.
Yes, father name is there, madam.
Where?
Father name is reflected in the cost title.
Cost title, full cost title is not. See the order 8/10/2024.
Yes, madam. 8/10/24 in the cost title, madam.
I have reflected in my eye also. In the cause title, it was reflected.
Shamakhara.
Shamakhara.
Original name,
It will be late Madan Khara alias Shamakhara.
you see, Shamakhara was already written.
I have written, but alias that Madan Khara was not been written. For that, the Belwan.
For the reason stated in the application, the same is allowed. A petitioner is allowed to amend the memo of parties by changing the name of the father of the accused from Shamakhara to Shamakhara alias
late Madan Khara.
Late Madan Khara. Late Madan Khara alias Shamakhara.
Yes, Madam.
Late Madan Khara alias Shamakhara. Yes.
So, Lordship permission. Item 46. Read of the wrongly 2414.
Which one? 2414. Just
Yes.
check it up.
I have taken it.
Yes. Yes.
My name may be reflected.
Yes. What is meant? Immediate schools. AC लिख देना.
49 and the first minute I play for Passover.
Passover with this 3:30. What is this matter? What is this matter? You?
केस में तो आगे नॉन एपेस डिसमिस नॉन एपेस डिसमिस तापर से रेस्टोर तो ऑफिस रे फाइल टाइप लो हमको कॉपी टाइप हो
Okay, simply urgent. Simply urgent.
ऑफिस में प्रोवाइड है कॉपी
Provide a copy. I will information. I don't think to continue. That is why you are asking for urgent.
No, my lord. Mr. Mahathi is not there. So
you must there listed this matter. So I am not asking more time. Not fixed date.
No, there is no fix. Yes. Serve a copy. Serve a copy. Then counsel for the petitioner undertakes to serve a copy of the petition on the respondent counsel. Leave the matter and so on. So to continue. Yes.
50.
Well, let's notice through special messenger may kindly be issued to the opposite party number 359.
Instruction in petition already dead. And lawyer must have instruction.
I'll talk
Dead is the complainant. It's arranging out the complaint petition.
The petition is dead, then what to do?
I'll take instruction.
The problem, you are already dead.
Other relatives have taken instruction.
It's said there has been lodged.
I hear it, but the
I'm moving the anticipatory application in respect of my clients for opposite parties.
I think he died.
Yes, committed suicide, but his loss, wife lost with her on the allegation that
There must be correct confirm. I just dispose that one. It is stated at the bar that the sole petitioner in the present case expired, has expired. Therefore, the petition has become infructuous according to the disposal. Yes.
51.
Yes. Notice on opposite party number 2. Notice on opposite party number 2 who has been served, but none appears for him. Even the none represent the opposite party number 2. Even none appears for the petitioner today. In the interest of justice, urgent. Yes.
I don't to mention that review application which my learned friend just now argued. They filed the writ appeal before the Honorable Chief Justice, and the order is that simply withdrawn, and that was dismissed as withdrawn. No liberty granted to the file review.
Withdrawn means that order stands. Single judge order stands. He asking for had it been allowed or something, this order would have been married.
He submitted that to granted liberty, and there are
liberty is not granted. You point out when the matter is taken up.
Yes.
Take out the printout and keep it.
Yes.
Bank versus.
Yes.
So arrange out a complaint.
Yes.
Arrange out a complaint case versus petition number 213 are aged about 85 and 95 years versus.
Yes.
And or tabular magistrate offences are tabular magistrate. Your 205 petition has been rejected, and that has been confirmed by the regional court versus
2 and 3.
2 and 3 versus.
And 1 means 75 years.
One is dead. One is dead.
2 is 85.
What are the offences?
Offences, lordships, that is 294, 323, 325, 379, 427, 446.
Your application is rejected.
My 205 petition has been rejected. In arising out of civil dispute,
Where is that order?
order lordships, page 2, annexure 2 is the passed by the land magistrate. And annexure 3 is the revisional court order, confirming the same.
And it's 3 is the revision order.
Revision order.
You went to revision court also.
Review court also confirm the. Remember, honorable lordships, old days are now due to very different any time through law, lordships.
What is the reasoning?
Reasoning lordships, they are telling since 2000, it is a case of 2018. At that time, in their frequent find, at that time, the leadership crops were village people are destroyed the crops. So
What is the reasoning of rejection?
that is the reasoning lordships.
Gravity of offense.
There's 20 lordships. Last paragraph, that is the.
The court says that 317 is
After
the
Chargesheet lordships, after Chargesheet, they may reprint to 317 lordships. So after lordships, now cognizance taken and someone has been issued lordships.
Then 317 also you can move.
Now someone will appear physically and
Once you have to appear,
there are
only once.
So
take bail.
old days
That's right. You appear through VC.
VC lordship from home, it is not possible.
Everything is possible. The offences are serious. The court says that once you appear, someone is issued. Once you appear, get the bail.
My minor offences lordships, civil dispute.
Never be faced.
And old days,
This is a case matter arising out of 1cc case.
notice has been issued and he is not, complaint is not
Complete.
service completed.
See, he's 85, 95 years, people going to the court and all.
Pretty offences.
Only 3 accused.
Yes, lordship, 2 accused, 2 things. One is dead lordship.
Sufficient. Notice was issued to opposite party number 2 on
Opposite is 1 lordship.
opposite party number 1 on 12/3/2024. 24. Despite service of notice, none appears for the opposite party number 2. The petitioner is agreed by the order dated 16/11/2024, passed in ICC number 19 of 2018 by Leonard S.T. James, Kamakhya Nagar, which has been confirmed by the an order dated 7/8/2023, passed by the Leonard Additional Assistance Kamakhya Nagar in criminal revision number 20 of 2021. At the instance of opposite party number 2, the ICC case number so and so was initiated for offences punishable under section so and so. There are 3 accused persons in the ICC case. Out of them, the accused number 1, Sridhar Naik, has already dead. The present petitioners are the present petitioner Dhanusa Naik is aged about 85 years, whereas Purushottam Naik is aged about 95 years. So they moved application before the trial court under section 205 CRPC for exemption from personal appearance, which has been turned down, which is by order dated
16/11/2021 by the learned SDJM, Canada. Against the said order, a revision petition was preferred before the Court of Additional Sessions, Canada, being criminal revision number 20 of 2021. The revisional court, by order dated 7/8/2023, has also rejected the application intra stating as under. The only criteria is 24, the only criteria. नहीं तारपुर लिख दो but as per the decision, as per the decision, as per the decision. ठीक है, ठीक है, last में करो. I have finished the documents placed before this court. It is apparent from the record that both the petitioners are at the late evening of their life. Subjecting them to face the rigors of the trial by appearing in the court is in fact is very harsh at this stage. The allegation made by the opposite party number 2 in the complaint case are minor in nature. Opposite party number are minor in nature. The court, after taking cognizance of the offences, punishable. What are the offences? Punishable under?
Lordship's offences is on 294, 323, 325, 379, 427, 447, 34 IPs. That is civil should be assured.
And there are civil disputes pending. There are civil dispute pending between the parties. In view thereof, I am up for the considered view that the prayer made by the petitioner deserves merit. Accordingly, the impugn order is set aside. The petitioners petitioners are entitled to move first application under section 205 CRPC. If such application is moved, same shall be favorably considered. With this observation, petition is disposed of. Yes, much over.
54.
When the notice was issued, what was the return? With your address
return? Address left without?
Without instruction.
Without instruction.
Therefore, the two address, the former address and the present address. Therefore, I permitted to file fresh required with both the address.
Pursuant to the order dated 29/10/2024, notice was issued to the opposite party number 2. However, the same was returned as a postal with the postal remark that address left without invited notice left, address left without instruction. In view of the judgment of the Honorable Supreme Court in Alvi and so and so, the service of the notice on opposite party number 2 is deemed to have been completed, deemed to have been sufficient, deemed to be sufficient. Leaves the matter for hearing on such. Yes.
56.
Oh, judgment legal.
I am appearing for the OP1 and 2 LRC.
Yes. OP1 and 2?
Yes, sir. Another date may be fixed, I will take me.
Yes.
Maybe on 22nd.
Sorry, sir?
1 week after election.
1 week. Why? What is this matter? 138.
No, normal.
91 application. 91 CRBC application was rejected.
Just now,
you are for petitioner.
I am for the petitioner.
You are not interested to argue today.
Yes, I will argue. My friend.
You are asking for time.
yes, sir. Just now I have received the factor and
so introduce appearance for opposite party number 2 and 3. and seeks an adjournment adjournment to file a response to the petition.
Yes.
Leave the matter up. Yes.
57.
Okay.
22nd one.
I will give a date. Yes.
57 notice was issued, my lord.
Not sufficient. Notice to the opposite party number 2 was issued by the order dated 4/11/2024. A notice is not sufficient. Petitioner is directed to take fresh steps to serve the opposite party number 2. Release the matter.
Brief including IO was also.
Yes. Sir, yes.
58.
58. Yes.
Belgium Miller, around 2020.
Which order modification you want?
2010-2021.
What do you want?
Minority allow the allegation subject to cost of 500. On the subject found out that not directed, minority not directed to surrender and go on. Only stay the.
No, I am not going by law university. NBW only the resort to the remedy available to you under law. It's not bail court. It's not bail court. Correct for order. Seek remedy available to you under law. No. That is a different story. NBW was issued a Quashing. Giving an opportunity to you go and appear, resort to the remedy under law. That's all. The application for modification deserves no merit. Hence, the same is yes.
59.
At the fourth counsel for the petitioner seeks extension of time to surrender before the court. How much? Okay. 2 weeks time extension 2 weeks time extension of 2 weeks time for to surrender. The petitioner is petitioner liberty to surrender appear before the court on 30th November. 30th November and seek remedy as per law. It's made clear that no further extensions are be given in any cost. Yes. And on any pretext.
My lord, this is 59 matter is picked to 3:30. That's same matter.
Yes.
I just appraising my lord, large occasion also directed us to prepare a note of submission as well as to prepare with a compilation of judgments of this High Court as a Supreme Court if any. My lord, it is a case the petitioner was working as a secretary of the cooperative bank. When he was working in the cooperative bank, there is a charge
against convictions.
Against conviction. So my lord has stay there.
Yes.
But only for sentence I file I also that you will final year and dispute here. Very short point is involved.
Vigilance, who is appearing for vigilance? Are you ready?
No, I am not ready because it is of 24. So
then I may be considered.
Let my lord and senior complete his part. I will reply on 30th. Your is a working day.
30th then partly I wait to hear in piecemeal. Are you
my lord I serve the copy to them.
No. I am not going to decide IA.
That's why say that on the time yes.
You consider 15 matter 2015 to the district and coming. So I am getting ready for 15 and 16-year-old matters. This is of 2024. So the petitioner
don't go by that.
Continuing in his service. He is not going to do anything else.
After conviction, if you will not sentence will stay, then how will
service? I am taking that part. He will not be dismissed from service. That
don't take assume by the my friend is
he is not so serious. So it can be hard.
It's a matter of management now. The
during the tenure of this appellant as secretary, has purchased the land for the benefit of the bank
without taking permission from the registrar of cooperative society. That is only.
This is a procedural irregularity.
Without taking any permission from the registrar of cooperative society, he has purchased the land or
Where is the criminality then?
misconduct in the
Misconduct you department will proceed.
it is when inquiry was made.
Any financial irregularity or any loss caused to.
That loss means the present market value is 37 lakhs. 37 lakhs, 36 lakhs, 41,638. This, it is an applicant has paid 1 crore 58,450, for which government sustained loss of 64 lakhs. 64 lakhs sustained loss. 64 lakhs. 64
What is the evidence you have reduced regarding the market rate?
Market rate, that is, it is there.
Evidence is there.
It is there. Market rate is there. Also, the officer witness during his tenure, the officer witnesses said that without the permission, this secretary has purchased the land.
That's a different thing. Permission, that's the irregularity.
Valuation report is there, document is there. Documents have been executed.
Within 2
1 lakhs 87,000. He has purchased it in 9 lakhs or more.
It's the crux of
That is the criminality.
Yes, I'm just clarifying this finish. I'm the secretary. The president and board decided to purchase particular land at a particular price. I don't know what is the price on these things. He told me he issued checks. We go and execute the document.
Those resolutions are part of the record.
And that is the board. This price has been purchased the land. What they have done, just like his private part in the board have done, that procedure will be to the secretary. And again, part 50% and started the building construction.
From that,
I know it's personally this very valuable land. They purchase from the particular land and 50% is sell to others.
Okay, let's put it on 30th.
30th Saturday is
working day.
It is working day. I have been better in the Nanital in 29th. 7th.
No adjournment. 7th. Small matter will finish that.
Yes.
At least we can say is the
maximum time 15 minutes.
If there is nothing, if it's the case of acquittal, if those resolutions are there on record.
No, not only this, my lord. The general would also approve it.
His accused statement about the market price, about the excess level, he has accused statement, this accused statement, he has accused.
Let us see that.
And that I clarify, my lord. It is a data issue. My humble solution is that I am an employee. These have taken decision. They are not even accused. If the accused is there, then the board of directors or the supervisor must be accused.
Let us see the resolutions are there or not.
Yes. I get to whatever record authority.
For the benefit of the bank, I have already issued.
Try and find out some, if it is tilted in favor of him, we will make record an acquittal. If it is like
my lord.
For the sake of vigilance. Senior will argue for his land.
You argue your statement, your argument on record, but find out the way how to, we are here to give relief.
No, absolutely correct.
Something is tilted in favor of the accused, the benefit should go to them.
Yes. That is
again, secretary of the bank
but if the evidence is there, nobody can help you.
No, evidence is not there. I should be cool.
I'll see that.
This is there. Evidence is there. No there. How we not invent any violation or any corruption.
It's not bail matter. We are accused.
Yes, sir. If 32 Indians are not coming and this the court will be passing the order against me, a convicted me. Yes,
prepare a note and come.
I have prepared it. I will have it. Yes. Put a copy out.
And reproduce the part of evidence which you have.
Within 2-3 days, I will give a copy to you.
Yes. Reproduce the part of You have produced the part of evidence, oral evidence.
Yes.
You are relying upon.
Yes.
The part.
Yes.
Yes.
I also rely.
Yes, that's right.
Because the main fact is Professional Operators Act is not applicable in.
That is the whole difficulty.
That is the whole.
So not technical definition of employee.
In fact, conviction will be retained.
Evidence is there, nobody can help.
Yes, I get from my friend. Yes, clarifying the question.
Yes.
What I need to submit, yes, sir.
62, 7th of December.
7 December. Village.
Malaz, in item 60.
If my nursery will keep it to 30th, it will not there, my estate will take time on 7th.
7th.
His Rasi have already paid this.
7th.
So many.
May I tell you one thing, my lord? Can it be same 3:30? Sir,
Sir, that is also Saturday. Let's see.
sorry. How much?
62.
Malaz, I appeared for the petitioner in item 62, Lordship.
Yeah.
Malaz, CBI has filed a reply, but the state has still not filed a reply, Malaz.
Yes. CBI is the CBI or also in this case or also.
CBI matter. Yes, CBI or state. Yes. Yes, Mr. Nayak, will you file reply or what?
So, Your Lordship, this matter has already been decided by the Honorable Supreme Court. And also the issue is covered by writ petition criminal number 53 of 2020, Your Lordships. It was decided on 23/12/2020. I'll give you a copy, Your Lordships. This issue has been twice settled, Your Lordships, once by the Honorable Supreme Court.
Let's see what is the issue first of all.
Yes, let her argue, Your Lordships. My sister
Malaz,
can
the
argue.
issue is basically that, Malaz, this relates to the Orthotattva scam, Malaz. Malaz, the petitioner, he has been accused, and Malaz, he had been accused, and thereafter, Malaz, he was also by way of the order in Supreme Court in May 2014, Malaz, the Supreme Court had directed that all the FIRs, there were about 8 FIRs registered, and the Supreme Court had directed that in different places of Odisha and Bengal, Malaz. And the Supreme Court had directed by the order that all the FIRs be considered under CBI investigation. So, Malad, CBI had undertaken the investigation. I had been arrested, Malad, and I have undergone the complete sentence.
Yes.
However, Malad, after that, there is one particular FIR which is of the same time when all those other 8 FIRs were registered. This FIR is also exactly of the same period, same cause of action, same everything, registered in a separate thana, and now I'm being issued summons on the basis of that when I've already undergone sentence for the same cause of action, Malaz. Absolute same cause of action.
Yes.
May I proceed?
Malaz, the FIR, the subject FIR was registered on May 10, 2013 at Chhatrapur Police Station in Odisha, and under the same provisions whereunder I have already undergone the entire sentence.
Yes.
So basically, Malaz, what the Honorable Supreme Court had held is that all cases registered under, and Malaz, I emphasize on the words all cases, the Supreme Court in its order dated May 9, 2014 had held that all cases registered against Orthodontto shall be transferred to the respondent number 2 in this case, which is the CBI.
Yes.
And it appears that
8 cases. Rather 8 cases. Total. That time there were only 8 cases.
Malaj, 8 abithila. Same time, this matter was also there, Malaj. Same time. Because Malaj, if you just see all the matters, all those 8 cases relate to that same time, 2012 to 2013. In this particular case, Malaj, the FIR is dated, Lordship, I'll just tell you, the FIR in this case is dated May 10, 2013. All the other cases which were referred, Malaj, are also of the same time. So, Malaj, you just see that the FIRs were all 2012 and 2013. So, and Malaj, the cause of action, Lordship, in the FIR also, which is in Annexure 3, Malaj, to this petition, the cause of action, Malaj, is something which is more than now.
What is the state now?
Well, the trial is over. I pleaded guilty. I have been in custody. I have undergone the entire term of imprisonment. And now thereafter my term is over, so I am out. Now, my lords, on the very same cause of action, there is summons were issued to me, which is when I approached this honorable court, and the summons was stayed.
Well, other victim may
Lordship?
victim must be some other victim. Some other victim might be filed another fresh case.
Yes, my lords, it's some other victim, but then same cause of action.
What cause of action you for every victim there is separate cause of action.
No, my lords, but then as per Supreme Court's order,
Nature of crime may be same, but the victims are different.
no, my lords, absolutely, Lordship, but then that is why the Honorable Supreme Court had said.
Suppose you have cheated 100 people, and one victim comes and files a case and you face the trial and sentence is completed. Doesn't mean that 99 people's grievance is addressed, and the crime which you have committed, 99 will be washed away.
No, my lords, I bow down, but my lords, in this case, what has happened is, my lords, for a moment, if Lordship would just consider the order passed by the Supreme Court, my lords, keeping all this in mind, my lords, even those 8 matters which were transferred, Lordship, also the victims were different. They were all different, my lords. Everybody had an individual cause of action, like Lordship rightly said. But my lords, only one, I mean, I was convicted only once.
Yes.
I can't be convicted multiple times for the same thing. So I was convicted only
It's
once.
not same offense, madam.
Madam, which paragraph of the order?
It's not same offense.
Which paragraph?
Lordship may, Malaz may just have Malaz, the order of Supreme Court, Malaz, it's of May 9, 20. Actually, Malaz may just have the annexure number 2, Lordship, which is the CBI FIR.
Yes. Yes.
Chargesheet, actually. Page
What is the relief you are seeking in this petition? Dropping of all the criminal prosecution.
Malaz, having already undergone the sentence for 8 cases where Supreme Court had said that all of them be transferred. Now, if respondent number 1, which is the state of Odisha, Chhatrapur Police Station,
different point in time, you have due people, many people.
Malaz, if respondent number 1 did not transfer this, Malaz, the list is there. Lordship will have page 35. For a moment, Lordship has page 35.
Yes.
Malaz, please see the cases that have been transferred.
Yes.
Malaz, this is the first one was Badambadi Police Station FIR.
Yeah, that's I understood. Show me the judgment, Supreme Court judgment you are relying upon.
Malaz, I'm sorry, that is not unfortunately part of the record. Malaz, it's an order dated May 9, 2014. Malaz, may just fix a date. I'll file the document on record. I'll file the judgment.
I can read it, your lordship. It's not necessary.
I mentioned it also,
Para
Lordship.
34, your lordship. Lordship,
Page 5
2 minutes
of my
time.
petition, Lordship may have, please. Page 5 of my petition. It's there. I've
Page
quoted it
5.
there.
Okay.
Paragraph 9, page 4 onwards, it starts. And I'll just read, Lordship.
Yes.
Thereafter, Supreme Court of India.
The question is whether the future call of transfer of ongoing university from state of so and so. Our answer is affirmative. In the circumstances, we are inclined to allow all these petitions and direct transfer of pieces. Yes.
So, Malaz, may thereafter.
You are underlining all such cases. You are underlining all such cases, but all such cases are qualifying the other sentences also, in which charge sheets have already been filed. All those cases will transfer.
Yes, Malaz.
And there is no bar for the subsequent cases to be registered or investigated.
It's not a subsequent case.
Lordship,
That is
let
the
me
point,
read that
Malaz.
line, your lordships. she's missing on the, your lordship, the crucial line. All cases registered against 44 companies mentioned in our order dated such and such, the CBI is also permitted, not directed. The CBI is also permitted to conduct further investigations into all such cases in which charge sheets have already been filed. Now, this issue, your lordships, was raised in IA 20. IA number 20, your lordships, in writ petition civil number 401 of 2013, argued by one advocate, Mr. Suresh Chandra Tripathi, who also argued for your lordships Alok Jena, who was the petitioner.
Yes.
Now, your lordships, here the issue was only the companies are different, your lordships. There the company was Arthadattva. Here the company is Seashore.
Yes.
Mr. Suresh Tripathi argued before the Honorable Court that CBI has taken only few cases of Seashore and other cases have been taken by the state government. Why don't you take all the cases, your lordships? This order is there, your lordships have given. In this order, your lordships, the
What is
Supreme
the
Court
date
is.
of the order? Could you just tell me? I don't have a copy of this order.
I have given it to the junior in court. IA number 20, order dated 30/11/2015.
Yes.
Order dated 30/11/2015, IA number 20, in writ petition civil number 401 of 2013. Same issue, your lordships. Exactly, your lordships, identical issue. One senior advocate, Mr. Ranjit Kumar, appeared for CBI, and his submission, your lordships, he further submits their further investigation in the cases that have already been presented before the magistrate by the state police will also be taken up, if necessary, and appropriate supplementary charge sheet be filed whenever such investigation is completed. Now, the Supreme Court admitted this. The Supreme Court said that if necessary, only CBI can take up the matter. Again, that issue, your lordships, was raised in writ petition criminal number 53 of 2020.
Yes.
In this honorable court, your lordships.
Yes.
Writ petition criminal number 53 of 2020.
Yes.
Which is a judgment by the division bench, your lordships.
Nice, I've seen it.
In which I had argued the matter for CBI, Mr. Katki argued for the state government. And your lordships, paragraph 35 and 36 is absolutely clear. The bundle of facts which gives rise to an action on claim.
Para 34, direct.
34, 35, 36.
Yes.
It's absolutely
Yes, how to deal with the judgment directly covered.
Directly covered. Your lordships.
May I just get the
And same Arthadattva. Same Arthadattva.
Can you just give
Pradeep
me the
Sethi has been convicted.
I don't think you have a case on that.
Malaz, in any case, Lordship, that apart also, Malaz, the cause of action arose in 2012 and 13, Malaz. The FIR is dated in 2013.
Just see this writ petition criminal 53 of 2020, and you read 34,
Madam, can put down the
35,
paragraphs.
directly what to what?
The same your lordship, the same argument was taken by senior advocate Mr. Milan Kanun Go, which was absolutely discarded by this honorable court.
Exactly.
Para 11, 12, 13, 14. And the operating part of the order is para
The
20,
first line, just I'll read 34 for your benefit, just read 34. It says, we are of the opinion that the separate trials in which are being made are in accordance with the provisions of law, otherwise it would have prejudiced the accused persons. Each instance cheating would constitute an independent offence.
And para 36 also, your lordship, with due permission, there is no continuity in action in respect of act of cheating of another complaint victim.
Yes, sir.
The real test is to determine whether multiple offences from the same transaction or not. By no stretch of imagination can be said that recurring
I'll
series of
pass
transactions.
I'll pass you. Yes, I'll pass you. इसको साथ लगा दो.
Malaz, there are a few other submissions also, Lordship. Malaz, there has been a huge delay in this present matter, Malaz. It's not just the question that he's already undergone trial. Malaz, the cause of action is of 2013. And Malaz, the issue is being raised, the summons have been issued for the first time in 2021. More than 8 years after the FIR was registered, Malaz, the investigating authority was absolutely had not taken any action from 2013 till 2021. So, Malaz, there is undue delay in the issuance of process, on which, Malaz, of course, there are judgments which say that if there is such a delay, Malaz, because there is no fresh cause of action that arose after 2013. Second, Malaz, that the summons are, my lords, I'm also relying upon, my lords, Article 20, subclause 2 of the Constitution, read with Section 300 of the CRPC. Because, my lords, the summons issued by the learned magistrate, it's infringing upon petitioner's fundamental rights under Article 20, subclause 2. My lords, because, and if I may, my lords, I'm relying upon Section 300 of CRPC, Lordship is aware. My lords, on this point, there is a judgment of the Supreme Court, my lords, Kolla Veera Raghav Rao versus Venkateshwara Rao, 2011, Volume 2, SEC 703. My lords, what happens in these cases, my lords, what the Honorable Supreme Court held, Lordship, is that while Article 20, subclause 2 only states that no person shall be prosecuted and punished for the same offence more than once, 300 subclause 1 of CRPC states that no one can be tried and convicted for the same offence or even for a different offence but on the same facts. Malaz, in this case, the facts are absolutely identical. Lordship, may please consider my petition, page 13, paragraph 29 and 30. Malaz, where I've extensively quoted where the Supreme Court has relied upon the law laid down, Malaz, as early back in 1953. Relying upon an English court's judgment, Malaz, judgment by the House of Lords, as to what amounts to double jeopardy. Lordship, please have paragraph 29 and 30 on page 13 of my, and 13 and 14 of my petition.
Yes, I'm there.
Lordship, if I may please read. Honorable Supreme Court in the case of so-and-so versus so-and-so has affirmed the law that Section 300 subclause 1 is wider than Article 20 subclause 2 of the Constitution. Supreme Court has held that while Article 20 subclause 2 only states that no person shall be prosecuted and punished for the same offence more than once, Section 300 subclause 1 CRPC states that
Madam, this goes with the fact that one person is tried twice for the same offence. This is not your case at all. So
it's not for the same offence.
Veera Raghav is in a different petition altogether.
Malad, that's exactly the point, Malad. And it doesn't, Malad,
I don't think you are covered by Veera Raghav at all.
Malad's court says that it's not the same offence. It's not restricted to the same offence, even for a different offence. The court holds that, Malad, but on the same set of facts. Thereafter, Lordship, may please bear with me.
Come to Mukul Hussain. Come to Mukul Hussain.
The question is not about, Your Lordship, the question is not about same, Your Lordship, the question is about same transaction and separate transaction, Your Lordships.
Yes, I am.
I would ask my sister to refer to one judgment, Your Lordship. Sapurji Sorabji versus Emperor.
Yes.
That is AR 1936, Bombay, page 154. It's a beautiful judgment, Your Lordships, which defines the difference between same transaction and separate transaction, Your Lordships. Here, Your Lordship, the complainant are different. The amount of misappropriation is different. The modus operandi is same, Your Lordships. Suppose, Your Lordships, in the same manner I commit a crime, I go to CDA Sector 9, Sector 11, Sector 12, Sector 5. The modus operandi is same, but the transactions are different.
I have also given a judgment regarding same and similar.
Where Your Lordships have quoted Lalu. Your Lordships have quoted Lalu Yadav's judgment.
I don't know which judgment I quoted, but I have given a judgment. Same and similar.
AR 1936, Bombay, page
There's a
154.
difference between same and similar. I reserve the judgment, madam. You give written submission. Yes.
I'll give written submission.
Give written submission. I'll just see. Okay.
Yes. May I be given about 10 days to give the written submission, Lordship?
Yes, yes.
Your Lordship, one small, Your Lordship may note down one small judgment, Your Lordships. Yes. Lordships, as far as the delay part is concerned, the delay was explained, Your Lordships, in another judgment. As regard to the arguments there is inordinate delay, it is to be noted that huge network was built by the companies all over the country, involving several stakeholders and institutions. Hence, the inability to submit final charge sheet is understandable.
And you give in writing that part, you produce and give it. Okay.
Yes, Your Lordship.
Okay. 10 days. 10 days. 2 weeks, huh? 2 weeks.
Order reserved, Your Lordships?
Or judgment reserved, 2 weeks time. Yes.
2 weeks for the written submission, Your Lords?
Written submission, Your Lordship, 2 weeks.
Within 2 weeks.
Okay, very good. I'm grateful, Lord. Grateful, Lord.
Yes.
63. I'm referring for the open number 2. On the last occasion, Your Lordship directed to
take instruction regarding settlement. Yes, I have taken instruction, she is willing to settle this with the dispute. Only thing may suggest to your lordship, the matter may be sent to High Court Mediation Center. She is coming from Ahmedabad. They will come from Ahmedabad. Civil suit initiated for the purpose. Oh, sorry, sir. Civil suit initiated for the purpose of seeking partition of the properties. Whatever her share, she'll get it. There is no dispute. We are not denying her share, my lord. But you cannot drive everything, my lord. Even once it had gone to mediation, it failed. Your lordship, if your lordship sees the mediation, yesterday it failed to today it may happen, tomorrow also. After all, brother and sister, our right will be established in the same suit. I mean, we are not depriving, my lord. I am not saying you have a right because you are the daughter. You are the legitimate daughter. You can do everything.
She has to settle because I have expressed my mind that I want it if you don't settle. You can't fight with your brother and everybody.
And mother said, I've been saying that.
I'm continuing the interim order and going to mediation center soon. Mediation center. You are appealing for opposite party number 2, no? The counsel for the opposite party number 2 on instruction submits that her client is ready and willing to settle the dispute with the petitioners. Mr. Sarma, learned counsel for the petitioner, submits that her grievances can be taken care of in the civil suit which is already
initiated by her.
A civil suit which is initiated by her pending in the
Learned Civil Judge Senior Division, Balasore.
Be that as it may, since the opposite party number 2 is ready and willing to participate in the mediation process, I feel it appropriate to relegate the parties to the High Court Mediation Center, and the coordinator is directed to fix a date and intimate service, awaiting the mediation report. Please the matter is also interim order to continue.
Lordship, the name of Mr. Vishwanath Mahapatal may be mentioned because we entered. Okay.
If you don't settle also, I'll watch it.
No, Lord. Tell him, last time also she was willing to settle. But the thing is that they are saying they are dragging this criminal case. Now, if you settle, this suit will be yes, she is willing to settle all the thing is that this criminal case is arising out of the incident where they confirm this opposite
with the arm reaching method of forward.
I will not.
You are the sister who will do it like this. Yes.
65.
65, my lord, my lord, I oppose it because, my lord, this matter has already become infructuous.
Yes, I am
proceeding in which my landlord senior has challenged, my lord, that has been finally disposed of by the land magistrate, which is a reviewable order before the landlord session judge.
Sorry.
Again.
Yes. But revision is pending before this road court. That is revision against what? Final order. Revision against final order is pending before this road. That is criminal division 461 of 23.
The 461 at least. This will be infructuous. That matter will be heard.
Well,
there is no more in this case.
No, tag with the. This will be disposed of as infructuous and that matter will be heard or what?
This cannot be infructuous, my lord and friend. I say, Lord, 125 application has been allowed in expert. Unless that will be the final order has been challenged, it is the other part of the expert. 126 application has been filed, that has been rejected. On the same day, the final order has been passed. It is a consequence here. It cannot be.
Okay, leave the matter along with the revision forms. Yes.
Revision 460.
Next.
66.
Yes, sir. How many matters are listed? 25. Yes, slow today.
Yes, in this case, the petitioner has approached the Honorable Court for quashing of the proceeding.
after hearing the case in the last dates, your lordships have pleaded to send the matter to the mediation.
What happened?
Mediation unsuccess because the opposite party not did not appear in that case. My lord, the mediation report is unplaced.
Who is appearing for opposite party now?
No, who is not appearing?
Here also no. Earlier, sir, anybody appear for opposite party note too?
But a tracking report says that it is sufficient.
There also notice was issued, it was sufficient, nobody came forward. What is this matter now?
Matter, my lord.
Huh?
Matter, my lord.
Matter,
no, my lord. The opposite party two initiated a case against a businessman named Sibo Sankar. Transaction of a printer. He has sold a printer to that Sibo Sankar. That machine, due to some lacuna in that machine, he again gave a new.
Where is the charge sheet?
My lord, I have filed as additional document, my lord.
Yes. Where is it? Charge sheet is not there.
I as directed by your lordships. ସବୁ ଗୁଡା କରିଥିଲେ
କାହିଁ ଚାର୍ଜ ସିଟ୍
ନା ବହୁତ ଦିନ ତଳେ କରିଛି।
Well, matter is referred to the mediation. However, despite service on the opposite party number 2, he or she, he did not appear before the mediation cell. Therefore, the mediation could not be successful. The mediation, the High Court Mediation Center is placed on record. Placed on record the report dated 19/6/2024. In the present matter as well, the opposite party number 2 is not appearing despite sufficient service. The petitioner is directed to place on record the copy of the charge sheet and other relevant documents. Leaves the matter such and such. In the internal, the proceeding before so and so state.
Well, IO number 3017 by 24.
3017 allowed. It's P. You file the charge sheet and all.
Already on
file is not there. Just take it up. I am saying the proceeding. Yes.
67. My lord, on the Mr. Pond is saying that yes, difficulty.
Lordship see the interim order. That interim order granted imbue, my lord. That interim order is there already. Yes, my lord. No, my lord. 15/12/2023. Lordship see the order passed in IA. The petitioner is to file a petition before the Law and Court below, praying for adjournment on the ground of fitness in this case.
On behalf of the
no interim order, but still that was trial as normal. No, that is not substantial. The court bill has proceeded.
Any date, your lordship, next week is.
Because I am the third attorney-in-law, my lord, span of 7 years. What will be offense? 498 offense is made. Here be my, there the in-laws. The seventh daughter-in-law will ask the son got married, divorced. Second, divorced. And third also. Why the third time you got married? No due diligence. That was not within my knowledge, my lord. No due diligence. That was not within my knowledge. Why do you even chance of settlement? I'm telling you.
My lord, he was sitting there. He requested me to apply your lordship because he has some difficulty. Then
fix a date. Next week. Next week, fix a date. Is it too difficult?
and fix it. Okay.
68.
Yes, sir.
On the last occasion, Honorable Court are directed to give the copy of this court on 10th to 23/10/2024 to the opposite side advocate in the court below. That is in the
yes. What is your case?
Yes, Your Honor, the opposite party is using the law and the due process and the abuse of law. He is taking maintenance amount from last 24 years from the petitioner, although the opposite party is staying at the house of the petitioner. And when we send notice to the opposite party, that is, we have to mention the address of the petitioner and the opposite party is similar.
Yes, Mr. Trivedi, is there any chance of settlement? Matrimonial dispute?
Matrimonial since last 20 years they are separating. Have 5,000 only entry maintenance. This case is
separated means there is
no issue for us. No, but my situation 5,000 per month. He is a teacher. Now he is claiming that since I have retired, so I will not pay. And the Lawrence Family Court has directed
no divorce petition filed, nothing.
No divorce petition.
Divorce petition has been filed by the petitioner now. Before 1 year.
Or still you get divorce, so you have to maintain what to do.
Even now, he has suffering in pain and under treatment at AIMS.
Whatever, but she is your wife, what to do? You have not separated, legally not divorced.
The opposite party is present at the house of the petitioner, and he is enjoying the house, and the petitioner is not present at the own house, and also the opposite party enjoying 4 acres lands of the petitioner. And other circumstances why this types of
that will take care of permanent anybody, but he need also.
Now the petitioner said,
okay, you have accommodated there is a house, no problem. There is a land, no problem. House will survive, she is not working. You don't have any how much you are getting after retirement?
30,000.
No.
38,000.
38,000 you are alone. What will you do to you? But you should be reasonable. He is your wife, wrong, right, whatever. You have not initiated the proceeding for separation. Till she is legally wedded wife, you have to maintain her. Higher side, the maintenance I could have interfered. It is only 5,000. Because 5,000 is nothing.
He's taking advantage of filing another case, and now he has filed another immense case against 293.
When it is announced, you come. I don't think we can interfere. I don't. Petition is agreed by the order dated 26/4/2023 and 17/4. Where is that order? Where is that order?
15, page 15.
15.
1
But there is I will tell one submission I want to tell. You see page number 22.
22. Yes. Yes.
That in the order of the 198, the loan advocate of the opposite party has claimed that he has never gone to the village club. And she has, although she has been staying, although she has been staying for 24 years at the village club at the house of the petitioner, but instead the advocates of the side, she is she's always saying that she is not present at village club and he has never gone to village club. And only using this type of ambiguity and the price to claim, the court has ordered this type of order to come with protectors. And again, but have saying that the opposite party, then she has received that from that address.
What is the area?
60,000 only. ସେ କହୁଛନ୍ତି ଯେ ମୁଁ ରିଟାର୍ଡ ହେଇଗଲି ମୁଁ 5,000 ଦେଇପାରିବିନି ବୋଲି ସେଇ ପାଇଁ ଚ୍ୟାଲେଞ୍ଜ କରୁଛି।
Area he may not be in a position, but he will keep on paying.
60,000 5,000 ବର୍ଷକର ସେଟା 2,500.
But now you consider it on insofar as
60,000.
I know I've seen
60,000.
Pay 20.
Only 60,000.
Pay 37 rupees and let me continue paying.
60,000.
You pay 30,000 from that of the area, pay 30,000 rupees and 5,000 rupees you continue till any order is passed. Okay.
As she is the president of the house of the.
Is something different and survival is something different, right now. So petitioner is the husband of the opposite party number 2. He is agreed by the order dated order dated 26/4/2023, whereby the court, the family court Nagar has directed him to pay 60,000 rupees towards the areas of maintenance and continue paying rupees 5,000 as monthly maintenance. Letter counsel for the petitioner submits that the petitioner has already retired. He was working as a teacher. He is not capable of paying the huge areas accumulated. He also submits that the petitioner, as the opposite party number 2, has been staying in the house provided by him, and she is also enjoying the landed property. I am not inclined to interfere in this matter. However, suffice it to say that the petitioner, being a retired teacher, cannot afford to make good the payment of rupees 60,000 towards the arrears of rent. Hence, on consent,
that was on 14/11/2023. That's 60,000. And in the meantime,
26/4/2023.
in the meantime, 1 year.
You take 30,000 rupees and keep on paying.
Now,
only move appropriate application there.
1,20,000.
60,000 he is not able to pay, therefore he is here. Again 1,02,000. 50%, 30,000 towards the areas of rent, and keep paying the maintenance regularly every month without class. And petitioner opposite party number 2 is 30,000. Opposite party is granted liberty to move appropriate application before the court below for variation of the maintenance if she is not satisfied with the same. With this observation, the petition will dispose of. Yes.
Item 75.
Item 134, the vigilance.
What can I do? Yes.
Item 148. That matter is covered under Sanatan Das case.
On that group matter. I don't know when that matter is.
It was directed to be listed currently.
Yes.
So it could not be listed and
Some date is given.
no, it took 4 months, 4 weeks. Prior to 4 weeks, your worship was placed to give the date.
It was listed somewhere in 28th or something. We'll check it up. We'll check it up and tell you. I will check it up and call him. Huh? Call him and tell him.
Item 75. Item 75. That boys, that case last item. This some students are not performing issue like this. I don't know the copy. This side copy. Now I need to report towards him past necessary.
No, we have received the copy, man. I'll take instruction.
What instruction? They are the informant. The informant, I don't know. What is? See, the problem is you went to the court and said, I don't know.
The client is expecting some money from these people. But you went to the court, you gave the complaint, you went to the court and you say that I don't know anything about it. And you should have supported the prosecution.
Yes, my lord. One more time.
No, my lord.
I'll take up tomorrow. Related to tomorrow.
See, what I am trying to do it. There are young people there. Students are involved. My lord, they do the only the prosecution side, the government don't set it. I don't know. My lord.
You are the complaint. You are the director or something.
Board, president of the board. It is your responsibility to give a complaint. So, nothing is coming tomorrow.
The matter is I'm taking up this to I don't 71. Slowly is authorized, nothing will happen. I'm 71. I don't 71. Respect the seniors. Let us go by seniors.
But there was a compromise.
71.
74. There was a compromise. The compromise decree has been passed. It is a condition that the husband parties will cooperate for passing of the criminal.
Offense?
But you know,
Bring them.
On both sides are also.
Oh, I need accused and complainant. I will not go with that. My lord, they may be degree may be good. Why can't they come? Are they agree? Even then they let we see. I am giving that facility. I want to see. Tomorrow something may happen. We may turn around and make allegation against you also. No, you may say today no. You let them come tomorrow. Tomorrow.
Which condition would be?
See, I'm not insisting on VC only. Only they should come. I will record that they are taking. VC, I am talking about this tomorrow. I can say thank you.
140 lakhs weekly. That matter is covered under.
Weekly don't, then it will be there. If I get the time, I cannot silence you all. You can never to continue only. I'm not taking it up very don't what is there, I thought you also may remember that the father is a whatever, but I'm not taking up the matter very the question of
70. Can you take up this matter after 25th, my lord?
After 25th.
Perhaps more than 5 times he has taken action.
Because of this,
See the order for a moment.
Yeah. I'm specific matter.
Okay. Go after tomorrow. Go after tomorrow.
22nd, station at Burger. That's why I'm totally unable to present this case before this one.
Inform her journey because I said that.
Can you take up this matter on specifically?
When you make it, it is made clear that no further adjournment shall be taken. Better, any circumstance and any circumstance.
Lordship item
20.
Lordship item number 70.
Don't extend your journey beyond 25th. Yes.
Lordship item number 72 may be taken.
If I am not saying anything, it will go for what? Yes.
73 is relating to the body.
Yes. Any mentioning? Okay. Thank you.